Honor, I think that's to cut off what happened at the founding, which is, the people had a right to alter or reform their government, and they chose a path for doing that at the founding through the separation of powers in the Constitution.
So you're saying that people had the right to alter or reform their government up to that point. Now they can do it, but only through the state constitutional amending process, which goes through the legislature.
No, Your Honor, and I think 2 or 3 different responses. At the founding, the people ratified the constitutional provision for amending the Constitution. And that is a choice at the founding that has not since been altered or reformed through additional constitutional amendments. It's not within the power of this court to amend through an alternative process, i.e. judicial decree, or by saying that the people have a newfound power to amend by statute, instead of to pass an amendment that stands on equal footing with the existing constitutional amendments.
So what can the people do today if the people want to alter or reform their government?
The people can advocate for a constitutional amendment. The people can also, elect and lobby and propose their ideas to their legislators during the normal legislative process. The people can initiate statutes. I don't want to leave the point that SB 200, the redistricting commission is still in place. And the legislators will still be politically accountable for whether they vote their maps up or down. But in some ways, it's very anti-democratic to say that instead of making the legislature accountable for those maps, there's an independent commission accountable for those maps. And it's ultimately the legislature's choice to decide how Utah's population is divided. And I think that that's what the people decided when they ratified Article 9. Article 9 has been subsequently amended, and it still says the legislature, all the while knowing that the people retain this initiative power, that again, it does not allow for a constitutional amendment. The people could have done that. Again, in Arizona and in other states, the people have a right to directly amend the Constitution. And at the founding, and again in 1900, that was not a change made here in Utah.
So counsel, the people's right to initiate legislation, to initiate statutes, as you put it, it's cabined in certain respects in your view. It cannot extend to something that ought to be done through the constitutional amendment process. Can you describe to me the limitations on the people's initiative power, full extent of those limitations?
I can do my best, but I'm going to start with saying you don't have to decide that here. And it's not a new proposition that the people and the legislature and this court and the executive branch all must act within the confines of the Constitution. That's what this court said in the Severe case. So that's not a new proposition. And as I mentioned earlier, the people can no more require this court to decide cases unanimously to the extent that's unconstitutional than the people can violate other provisions of the Constitution, then the legislature can violate other provisions of the Constitution. What I would do, Your Honor, is just repeat that language in Severe, that the people cannot by initiative violate the Constitution, but we need not reach that here because we've said multiple times that the legislature's power is co-equal and concurrent with the people's power, and what happened here is no different than what happened in Grant, and there's no other way to strike that balance struck in Article 6 between the people and between the legislature than to allow both of them to engage in this back and forth. And again, SB 200 was a real back and forth, and it passed nearly unanimously.
I guess part of the problem is the legislature always holds the trump card here. People pass an initiative, legislature changed it, you argue in your briefs, well then the referendum process is available. That seems like an empty promise. I mean, that could continue indefinitely. Ultimately, under the system that you're suggesting, the legislature is always going to have the final say. Is it fair to say it in that way?
No, I don't think that's right, Your Honor. I think that as a general matter, and then setting aside constitutional parameters that could apply in this case or any other case, as a general matter, that ping-ponging back and forth is just part of democracy. And that it's costly for the legislature to vote down people's initiatives. Especially, for example, imagine a people's initiative that passed by nearly unanimously, which is not the case here. The initiative passed by something like 6,900 votes. But imagine an initiative that passed nearly unanimously, and the legislature comes in and gets rid of the whole thing, doesn't even keep any part of it. There are severe political consequences of that, and it really undervalues the power of the people to say that the people can't then do anything about it, either by passing another initiative and going at it another way. And then you also mentioned the referendum power, Your Honor. As a general matter, the people can have the trump card for the legislature. That referendum power can't be implicated here because the congressional maps passed by more than a 2/3 majority. But as a general matter, the people have the last word in voting up and down.
So let's say a referendum would have been possible here. It wasn't because of the 2/3 vote. Let's say that it was, and the people did a referendum on SB 200 and voted it down. Could the legislature just repass SB 200 in their next session?
I think that raises constitutional questions of whether you're violating the law, like circumventing what the Constitution actually says.
How is that different than what you're arguing?
Right. I think what I mean is like whatever the text is, like it would probably present an interesting constitutional question if the text of if the people vote down SB 200 by referendum and then the legislature comes back, like it's difficult to say.
I don't see how that's different than what you're saying, how you're saying we have to read the initiative power. Because you're saying the legislature can always enact, always repeal, always amend anything.
Oh, Your Honor,
and so if the people voted down a bill, why couldn't the legislature enact it the next session under your argument?
Yeah, sorry, I misunderstood your question about who started where. So imagine that the people pass an initiative and then the legislature amends it by more than a 2/3 vote and the people want to send it to depending on who starts and who ends, there might be constitutional problems with the ping-ponging. For example, the people by initiative probably can't do what they couldn't do by referendum, is the point I'm trying to make. So if there's a bill of the legislature that passed by a 2/3 vote and it's not subject to the referendum power, then that's an interesting constitutional question, whether the people could, I'm having trouble articulating in normal English words, but it's a difficult question whether the people could then override that limitation on their referendum power by using their initiative power. Does that make sense?
Let me ask it this way. So I guess I'm wondering, are there any limiting principles on the argument that, look, it's inherent in the legislative power that the legislature has to enact, repeal, amend, which is certainly the case, right? That's all part of legislating. Your argument is that doesn't really change with respect to initiatives, even though it's a shared power and the people have reserved for themselves legislative power, the legislature can still amend, can still repeal because it's co-equal. Are there limiting principles on that? So for example, if the citizens pass an initiative, could the legislature, if they decided, and this is hypothetical, I'm not saying they would do this, could they decide, look, next session, if the citizens do this, we're just repealing it? Is there any limitation on anytime citizens have an initiative, could the legislature just repeal it?
I don't, as to constitutional limitations, I don't think so based on what this court has said in Carter and Gallivan and other cases. To say that there's some constitutional limit is to read something into the Constitution that isn't there. That's not to say that there aren't political limits.
Okay.
But the only constitutional limit I see in Article 6 is the limitation on the referendum power, where bills by the legislature passed by more than a 2/3 vote can't be subject to referendum. That express limitation leaves no room for some implied limitation on the legislature. And again, that's not to say the legislature has the last word. Within constitutional parameters, I think it's just a function of our messy democracy and a function since the amendment to the Constitution in Article 6 that the people in the legislature might go back and forth and that they are a check on one another.
How does the back and forth happen, though, I guess is my question. So your reading of the initiative power is that, and the way that you're reading our case law, is that the legislature could always repeal an initiative. There's no constitutional limit on that, even though the people are exercising their initiative right. So we've got the ball's been hit to the legislature's court, they repeal it and replace it with a new law. And the citizens decide, we don't like that, we wanted the one that we passed. And so the citizens go through the steps and have a referendum on the legislature's law. So they vote down that law. Is there anything in the Constitution, and 2/3 is not at issue here. This is just a regular. Is there anything in the Constitution that would prevent the legislature from saying, you voted that down, we did like it, we're reenacting it?
No, I think you've actually just articulated the ping-ponging. So there's an initiative, there's an amendment, there's a referendum, there's a legislative enactment, there's an initiative. In theory, I think the Constitution, the only way I can read the terms in Article 6, especially against the backdrop of other state constitutions, is that that's, in theory, the right reading. In practice, there will be serious political checks on that.
When do the people have the last word, though?
The people would have a last word when they vote on a constitutional amendment by a majority. The legislature absolutely cannot override or do something unconstitutional by statute that would contravene a new constitutional
So you're
amendment.
saying they can't have the last word through the initiative process? The people structurally don't ever have the last word?
Well, the people don't, and the legislature might not unless that 2/3 provision of the referendum. I mean, no one has the last word. That's the very spirit of Article 6.
So one thing I would like you to address, the plaintiffs have some evidence from the founding, from the founding of this particular amendment of Article 6. And in reading how the amendment was talked about in speeches and newspaper articles of people advocating for people to vote for this constitutional amendment, giving people the power to directly legislate. Two of the themes that seem to be present are, first, that people should vote for this because people need this when they disagree with the legislature. When the legislature is not doing something that they want, or they did do something that they don't want, the people want to have a direct check. And there was an assumption that once the people did that, that it would be effective, that they would have the last word. That was how it was talked about. That was sort of assumed. Do you disagree with that was the way that it was talked about, or that was the understanding of people as they were voting for this initiative right back in
I agree
way
with,
back then?
I agree with you up till the very last point,
Okay.
which is the people, which is the last word point. That maybe as a political matter, they thought they would have the last word, but certainly when you're looking at the constitutional text, which is where this court's analysis begins, that it is a shared power. And again, I don't think you can say that the people should have had the last word here, and that somehow makes all of this case justiciable when this court has said that the powers are co-equal and concurrent. And again, when what happened through SB 200 was by a near unanimous vote of the legislature, they took what the people did and they amended it in part to resolve some constitutional uncertainty, very similar to what happened with the Medical Cannabis Act and that went unquestioned in this case, in this court in the Grant case.
Counsel, are the powers co-equal and concurrent relative to the redistricting process? Or is that exclusively the legislature's province? It seems to me there are a couple of arguments. One, this initiative was unconstitutional from the get-go maybe you're arguing this, in that this is a redistricting power is a power reserved to the legislature. The other argument is, regardless of whether it's unconstitutional in the first instance, the legislature has the power to freely amend or repeal any provisions. What are your thoughts?
I think that you can decide this case on the narrower grounds of the powers are in general co-equal, and then again repeat that language from Severe, that there might be other constitutional limitations on either the legislature's power or the people's power, because this case involves redistricting, but we need not reach that.
There's other constitutional limitations, but I guess I'm asking specifically, do you view the legislature's redistricting prerogative as something that makes unconstitutional any initiative that speaks to redistricting?
I'd hesitate to go that broadly, Your Honor. And I think Article 9 plainly vests the power, that plainly vests the power to divide the state into districts to the legislature specifically, not the legislative department. But I don't think the court needs to walk down the line of something, what's substantive versus what's procedural, and what parts of Prop 4 might have been constitutional and what aren't. Those questions aren't presented here, because at the core of this case is whether it's within this court's power to adjudicate those claims of partisan unfairness, given that constitutional text, and given the absence of an amendment by the people and only a statute. And no one at the founding would have conceived of an implied right of political success or fairness for the major parties in redistricting that this court would then be responsible for adjudicating.
Can I ask you about that? Oh, go ahead.
No, you go.
Okay. Let me give you a hypothetical just so I can understand better your view of the Utah Constitution and the provisions that are at issue at counts 1 through 4. So let's say the legislature passed a law that says, from here on out, we're only going to put the nominee who passes through the Republican convention on the ballot. Right? Anybody can register as a Republican, anybody can go in and advocate for who they want to get that nomination, but that's the only one that's going on the ballot. Can they do that consonant with the Utah Constitution, or is there a provision that would prevent them from doing that?
That sounds similar to me, Your Honor, as the question raised in the Anderson case, which is this court's only case about the free elections clause. And Anderson seems to suggest the legislature could probably do that, or it doesn't raise a free elections clause problem to do that. Because the rights protected by the free elections clause and other provisions are the right to cast a vote versus the right to have your particular candidate succeed.
And based on your understanding of the Utah Constitution, you believe that would be a constitutional exercise of legislative power to say only Republicans will be placed on the ballot?
Oh, only, I heard you say only Republicans on the ballot versus like each major party.
No,
you're saying
only
it's
Republicans on the ballot.
I think that would be a problem, Your Honor.
And why would it be a problem? Which provision of the Constitution would that violate?
The free elections clause, it looks no different than what King James was doing with Parliament that led to the adoption of the free elections clause in the English Bill of Rights.
So what's the limiting principle on the free elections clause that would not implicate partisan redistricting? If you believe that that is improper, why could we not adjudicate a case with partisan redistricting?
The limiting principle is just that. The plaintiffs haven't alleged that they can't vote for their candidate of choice. Everyone has equal access to the ballot. There's pre-existing First Amendment case law that ensures even third parties get fair access to the ballot. There's some play in the joints on the free elections clause in particular in the Anderson case, and just how far the legislature can go with write-in candidates. But the limiting principle is the candidates of choice are on the ballot, and no one is coming to the voters or the candidates as they were in King James time and saying, you can't run or you can't be on the ballot because I don't like your policies. But that's never been translated historically to a right to win, and it's certainly never been historically translated historically as a right to win that this court gets to referee. Another limiting principle, Your Honor, that the plaintiffs have rested their case on, but that isn't applicable here, is that at least since Westbury versus Sanders, there's a limiting principle with numerical equality in districts, and that as an objective matter, each person's vote has to carry an equal numerical weight. That's a limiting principle that this court can adjudicate. There's an entire corner of the US government devoted to counting people by race and by all sorts of other metrics. There's no equivalent corner of the US government or the Utah government counting people based on the likely candidates they're going to vote for 2, 4, 6, 10 years from now. And that the malapportionment claim also has some constitutional hook. From the ratification of Article 9 is spoken of an enumeration. The as ratified version in Article 9 also contains Section 2 anticipating that the legislature would prescribe numerical ratios for apportionment. And even then, even in Parkinson, even with that constitutional text, this court said it wasn't going to question the wisdom of the legislature, whether the ratios were too big or too small. And it took until Westbury versus Sanders to say that, no, the court needs to do more than that. And here, there's no problem. I think there's 817-some thousand people in each district, and they don't deviate by a single person.
So in your view, the free elections clause applies to malapportionment claims and to ballot access claims. And anything else?
I think the free elections clause, I would actually state it in its substantive scope and then figure out from there what they apply to, what it applies to. So the free elections clause guards against, or ensures, guarantees the free exercise of suffrage. When a voter goes into the voting booth, they get to vote for whomever they want without bribes, without intimidation, without coercion.
But if the legislature says that's going to occur at the convention level, that would violate it.
If the legislature says only Republicans can be on the ballot, again, I would go back to King James. That looks a lot like King James picking parliamentary candidates and ensuring others don't get on the ballot. So that's a real problem, again, within the limitations of what this court already said in Anderson.
Did you agree with Justice Pierce, though, that malapportionment would also be cognizable under the free elections clause?
I'm not sure it's a good fit. Honestly, I think malapportionment to me makes much more sense under the Uniform Operations Clause, but I suppose the problem with malapportionment under the Free Elections Clause is the history of rotten boroughs that persisted after the English Bill of Rights. And so I'd hesitate to say, it's definitely, within the history of the Free Elections Clause, when British Parliament tolerated malapportionment long after. They were still districting by counties or geographic area and not strictly by people. But it is a Uniform Operations Clause problem to the extent the law in operation puts, historically what would happen is a person in Salt Lake had far less numerical power with their vote. Like they had one representative for tens of thousands of residents, whereas someone in Daggett County has one representative for fewer than 1,000 residents.
But do you recognize that there are a series of state court cases, even contemporary to Utah adopting this, that do recognize malapportionment claims under the Free Exercise Clause?
Under the Free Elections Clause?
Free Elections Clause.
I think that might be true, although my familiarity with those cases from the 19th century, again, are talking far more in Equal Protection Clause principles. The Wisconsin case is a good example of that. But either way, that's not at issue here. And for this court to go beyond the problem of numerical malapportionment and to try to decide what is fair, what is a safe district, what is the baseline of political fairness, that's going to require something more something more for this court to hang its hat on than the absence of text in Article 9.
I guess my question was getting at whether the state concedes that the Free Elections Clause has to go beyond something more than just preventing intimidation or lack of access to the ballot, whether it can sometimes involve the process because it has been applied in malapportionment claims. But I take it your position is no, the Free Elections Clause is just about access to the ballot.
I'm not sure either way. I think the more modest approach is to say that any malapportionment claim just very much sounds in an Equal Protection Clause problem or a uniform operation problem. That's how the Supreme Court's treated it. That's how other states have treated it in the 1800s. And that makes great sense. There's an actual, in the enforcement of the law, as the law is carried out, there's an actual numerical objective inequality where tens of thousands of people are given one representative and 1,000 people are given one representative. I would also say to the judicially manageable standards point, so we have the census, we have objective data, we have a very easy test under Westbury. Zero population deviation unless, absent a very high and stringent standard rarely met. Here, there's no similar standard. There are only political standards to decide how much is too much politics and redistricting. And on page 37 of the plaintiff's brief, they have conceded that only extreme and durable partisan gerrymanders rise to the level of constitutional infirmity. So the amount of politics is not zero.
So can I circle back to Justice Pierce's question that started us off? If we disagreed with you on count 5, on the citizens initiative, and the standards that the people voted for were in place, so specific partisan neutral standards and a requirement that there be no partisan gerrymandering, that it's not tolerated. That seems to solve your lack of standards problem and your justiciability problem, because the initiative puts that at 0. Am I right that that solves your problem?
I'm not sure it solves my problem because the initiative would still be a statute, and a statute can't trump the text of Article 9.
Okay, but
Then
that
we're back to
aside,
where-
just looking at justiciability and your argument that there's just no standard, we can't judge this because if some is allowed, it's really hard to decide how much is too much. But if we had the standards that the citizens passed outlawing partisan gerrymandering, that would put it at 0. It'd probably, I think it has the same caveat that all the other standards do, as nearly as possible, or whatever the specific language is, but basically saying, we don't want it. We don't want partisan gerrymandering anymore, is what the initiative said. That seems to solve your standards problem.
I don't think you can impose, and the initiative is still a statute, it's not a constitutional amendment, is that right?
Yeah.
So I don't think the legislature, or legislation, statutory legislation, can impose standards that take away the legislature's substantive power to redistrict.
But I'm just talking about justiciability and whether it can even be measured, because I think that's what you're saying. It's impossible to measure this, right? But when something's at 0, it can be measured.
I see what you mean. Okay, so absent the structural concerns in the statute versus the Constitution, I don't know that we would be making the same argument if the answer was 0. And 0 is a standard that this court measures in malapportionment claims and likewise in racial gerrymandering claims. It's verboten. But given the nature of the claim, there still might be some problems if the standard is 0, depending on what the test is. Because citizens naturally gerrymander themselves, and so to determine whether something is a pre-existing, what is fair, for example, what is 0 in Salt Lake County, might look really different than what is 0 or what is fair in Utah County. And that baseline problem is one that still persists. Even when the amount of permissible partisan gerrymandering is 0, because you're going to have just natural political lean of districts. This is something the Supreme Court recognized as early as Veith. I think Justice Breyer's dissent does a fabulous job of this, of explaining people live by like-minded people, and it just so happens that highly concentrated areas have more Democratic-leaning voters, and more rural areas have have more Republican, evenly distributed voters. And then there's a particular problem in Utah, which is Utah has more than 500,000 registered unaffiliated and third-party voters, and if the amount is 0 and we're trying to count Democratic voters versus independent voters and Republican voters based on past races, that really doesn't give the independents a seat at the table, because past races they might have voted for Republicans or they might have voted for Democrats. So I think there would be far fewer justiciability problems. 0 would be a case that's a lot easier to try than this one, where there's some amount that crosses the line, but we don't know what it is, and the court has to tell us what it is because the Constitution doesn't. There might still be some problems, but there are far fewer.
Can I push back on your, I'm sorry, one thing that you said, can I push back on the idea that the only way to outlaw partisan gerrymandering is through a constitutional amendment? In Rucho, the Supreme Court, when they were talking about not condemning these claims to echo and avoid, they talked about two different ways that states could address this. One was through constitutional amendment, the other was through legislation, and they were actually citing legislation that would change this. Isn't your argument that this has to be done by constitutional amendment inconsistent with what the U.S. Supreme Court has said?
Your Honor, I think the examples cited are constitutional amendments. So Florida is a constitutional amendment, Ohio is a constitutional amendment, Missouri is a constitutional amendment. It might be that the court adverted to some legislation where you might have different versions of Article 9, and you do have different versions of Article 9 all across the country. For example, in North Carolina, I believe they have actual substantive compactness requirements and other such requirements in their constitution that could be fully consistent with further elucidation through a statute that then the court has some power to review. But here's what we know since Rucho. Since Rucho, many states by constitutional amendment have removed redistricting authority or cabined the redistricting authority of the legislature by constitutional amendment. They've done so in unique ways that are very informative here. Ohio, I think, is the best example. It gets away from your zero problem. Ohio says the Supreme Court of Ohio will have original jurisdiction to adjudicate whether the distribution of districts is proportionate to the statewide distribution of voters. That's far beyond the default rule of single-member voters, but it's pretty easy to administer, where if you've got 70% of people voting for the Republican governor, then you want 70% of the resulting districts to look Republican. That's the sort of specificity that Rucho is anticipating.
And Rucho did cite to several constitutional amendments, but it also cited to statutes. It cited to Iowa and it cited to Delaware that were actually limiting the ability to do partisan gerrymandering by statute.
And I want to,
but you'd say that might depend on their unique constitution.
I think, and that's 50 imperfect solutions, Your Honor. I don't think you can say just because Iowa can do it by statute or Delaware can do it by statute, Utah can do it by statute. Utah's Article 9 is one of the sparsest redistricting provisions I'm familiar with, I think you just have to go back to basic justiciability principles, where if a matter is committed to another branch, as I think Article 9 commits policy decisions in redistricting, or if there aren't judicially manageable standards, the scheme in Iowa is very reticulated. It's very clear about what's allowed and what's not allowed. Then it's left to the political branches. And again, Congress under the Federal Elections Clause can supervene, and it can pass a fair districting bill. The other thing is, Rucho doesn't speak in a vacuum. In Moore versus Harper, the Supreme Court has said, that courts can't transgress their ordinary power of judicial review, and so the court cannot do what is otherwise required by constitutional amendment. I think the framers would be shocked to know that this court could move the line between districts 1 and 3 from 39th South to 33rd South on notions of fairness.
I was going to say, they might be shocked by that, but I don't think they'd be shocked by the court exercising judicial review to say, does this meet constitutional standards? I think they bake that into the Constitution. So, they might be a little shocked by the court drawing maps, but I don't think they would be shocked by the thought that this court would say, yes, this does not pass the standards that you met. And I can see you're nodding. So let me just ask you another question about Article 9. In your view, would Article 9 have prohibited the legislature itself from articulating standards in statute and saying, we all agree these are the standards that will guide our redistricting process, and then creating a private right of action for anybody who thinks that they transgress them to litigate it?
I think that's a harder question because...
I think it is too, but I'd like an answer if I could, please.
Yeah, the text of Article 9 says the legislature, and so in the same way that the legislature passes tax statutes pursuant to its taxing authority, the legislature can pass... They do pass redistricting statutes pursuant to their redistricting authority. And here's where the rub is. There might be some limitations where legislatures cannot bind the hands of future legislators. And so imagine a world where the legislature says there shall be fair districts everywhere. Every district has to be 50-50, intensely competitive, even down in St. George and even up in Daggett County. And you cannot override that law, future legislators, except by a 2/3 vote. That, I think, poses a real constitutional
I
problem.
agree with you there, but let's not play with my hypothetical that much. Let's stick with the one I gave you, and let's just say the legislature says, this is going to govern our maps, right? These are the standards we're going to put in place. And any voter who believes that we have transgressed those can go and challenge it, right?
Yeah.
And they pass the maps, they don't do anything when they pass the maps to say, okay, we're going to change those standards. Those standards are still in statute.
Yeah.
Is that consistent with Article 9?
Legislatures do that consistently. So in many other states, you see legislatures, have either language in the bill itself or some language that precedes the bill that says, here are redistricting criteria by statute. And I want to say, and I can check this for you because I'm not 100% sure, but I think North Carolina might have done something somewhat similar to that after Rucho, or at least the bill was proposed. It was a statute. It wasn't a constitutional amendment. So I think the legislature can do that just as the legislature passes legislation to effectuate its redistricting power, so long as they're not binding the hands of future legislators. I did want to address your point about judicial review, if
Sure.
I can. So you're right that since Marbury versus Madison, which well preceded the state's founding, that the court's power of judicial review was understood to review the constitutionality of statutes. But Marbury is careful when saying that. And at page 170 of Marbury, the court says, they call it an extravagance so absurd and excessive to propose that this court has the authority to review the constitutionality of anything the other branches say, and they say the province of this court, and this is what matters here, the province of this court is solely to decide the rights of individuals, not to inquire there how the executive performed its duties in which they have a discretion.
No, I get that, but you understand that under the Utah Constitution, there's judicial review provided for that isn't dependent upon Marbury versus Madison.
I do, but this Constitution in Article 8 talks about the judicial power, and at bottom in Marbury it was about the judicial power, and as this court said in my essay, of course, what was understood about the federal Constitution, similar terms, while not binding, certainly is informative. And I think that's helpful here, right? The ratifiers understood this court's judicial review power to mean that it could review the constitutionality of the legislature's acts. Just like the court, ironically, in Marbury, reviewed the constitutionality of the First Judiciary Act and said, you gave us too much authority, right? That is an important check on the separation of powers. But in saying so, they said it's about individual rights. And in Marbury, the question wasn't whether, the question was about whether Marbury's commission should be delivered. It wasn't about whether more commissions should be delivered to Jefferson supporters versus Adams supporters. And so I just get back to the same political question standards in Marbury, the same political question standard in Rucho, and this.
I hate to interrupt you,
You're
but
okay.
before we move on from Rucho, as I read it, Justice Roberts, in his majority opinion, basically says, gosh, who knows what fairness is? Fairness is in the eye of the beholder. Who knows what partisanship, how much partisanship is too much. This is not a court issue, not just justiciable, making all your arguments. But then saying, but, these states, maybe they can do something. And we've talked about constitutional amendments and talked about legislation, but I think it's telling that Justice Roberts specifically says, and you know what? A number of states are creating these independent commissions, like Michigan and Colorado, cites that with favor. And I guess your response would be, well, Article 9 changes the landscape, and he's not anticipating that. Is that your response? Does your response go beyond that?
No, I think that's where I begin, and maybe I see it the inverse, which is Chief Justice Roberts at the end of Rucho, or the court at the end of Rucho, is anticipating that there might be different state solutions to this. And he's not prescribing a one-size-fits-all. And the court is very much as conscious that every constitution is different. So take, for example, Arizona versus Utah. In 2000, Arizonans, because they have the direct power to initiate an amendment, created the Arizona Independent Redistricting Commission. And ultimately that was deemed to be constitutional under the Federal Elections Clause, and that's how the system works in Arizona. In 2008, the people here ratified slight changes to Article 9. They didn't change the term the legislature, and the voter information pamphlet said, we're just confirming that the legislature is going to continue to do what it always has done, but we're going to give them a little more time to do that. And they did that against the backdrop of the Arizona constitutional amendment. That's okay, and Rucho anticipates that that's okay. And I would urge this court, before deciding that the landscape in Utah is sufficiently similar to the landscape in these other states, to look at the particular amendment language. It gives the court a standard so that the court isn't doing politics. I think the Ohio one's the best one. Missouri is a good one too, where at least through the language, I'm not admitting it's easy to apply, but it at least gives the court something more to do. And I do want to address the...
No, I think that's the thing, you know. I mean, Chief Justice Roberts is decrying the fact that the federal courts just haven't been able to develop the standard. But he basically says, but there's hope. Maybe states can do it. Here, as has been noted in some of the previous questioning, the citizens have provided standards. It seems to be almost a direct response. Well, I don't know if the timing is here. Almost a direct response to the problem that Chief Justice Roberts has identified. It seems clear that he's concerned about partisan gerrymandering. Just feels that the solution is in the states, not the federal government.
The solution is in the states, and the Elections Clause makes very clear that that solution has to be consistent with the state's constitutional division of authority. And the people by initiative and the legislature by their own statutes cannot otherwise transgress the Constitution. Nor can this court step in and become an independent redistricting commission itself and apply standards by statute when there's when the delegation of authority is to the political branches, both under Utah law and under federal law for the congressional districts.
In a sense, we don't have that division, right? Co-equal. Together, the legislature and the people, as they, through the initiative process, share this legislative power. I mean, that's kind of the rub, right?
They do share the legislative power, and as things stand now, SB 200 says that the commission should aspire to make politically neutral districts, and then the legislature will publicly consider those and take whatever political fallout there might be from failing to pass them. And just to get to the political nature, if you take a look at page, I think it's on 38 of the complaint, that's at page 40 of the record, you see these choices that you'd be faced with. The commission, their orange submission, proposes 2 extraordinarily rural districts where people from St. George all the way up to Daggett County are together in a district, and then there are 2 very compact or smaller urban districts along the Wasatch Front. Here, the legislature made a different choice that's somewhat that's consistent with the concerns of the ratification, where they said, we have 75% of Utah's population along the Wasatch Front, and we are going to divide that in 4 ways so that we maximize the voice of urban Utahns and rural Utahns in Congress as part of the delegation, and that rural voters not just have 1 vote, but 4 votes, and urban voters have not just 1 vote or 4 votes. And so long as we are in perfectly apportioned districts, that is fully within their discretion, which since Marbury versus Madison has said that creates sort of this non-justiciable issue. It's only a political question to decide whether that's better or the orange submission is better, which many might find unfair. A Republican voter in Daggett County included within with a Republican voter in St. George might say, what the heck, why my representative is representing this large swath of the state. Independent voters moved in and out of districts based on their past voting history, predicting their future voting history, might think that's unfair as well. The other fairness questions that this court would have to consider, because the constitutional text and in some ways even the Proposition 4's text leaves somewhat open, is what's fair? Is it a competitive district or is it a safe district? I think the plaintiffs here want a safe district in Salt Lake County, anchored in Salt Lake County. I don't know that a Republican might have a claim against that district. An independent might have a claim against that district. The independent might say, no, my fair district is an intensely competitive one where I have no idea from election to election who from what party is going to win, because that's how I keep my representative accountable. And there are no tools except for political ones by which this court can adjudicate that question.
I wanted to ask one question about malapportionment claims. So I understand your argument about it's really hard to adjudicate fairness, and what does that mean at a larger scale? And that quintessentially when we review something, we look for violations of individual rights. My understanding though of the plaintiff's allegations is that this affects individual voters' rights because their votes are diluted. And I wanted to ask you, so in the malapportionment claims, it's numerical vote dilution, that's easy to measure, but the rationale of it is that everyone's vote should be counted equally, numerically. Plaintiffs, I think, allege, and correct me if I'm wrong, that based on the development, the technological development of how big data can be used to really slice and dice up communities, and the huge amounts of personal information that are collected about people now, that software can sort of do the same that you could do in malapportionment, that basically it can dilute an individual voter's, the weight of their vote. So I agree with you, a lot of the talk about weight of votes, that's in malapportionment claims. We haven't had a redistricting claim like this before, so we haven't addressed it in that context. But how does the rationale underlying the problem, the uniform operation of laws problem with malapportionment, if plaintiffs are able to prove their allegations and show that, you know, the big data collection and the software tools that we have now can effectively, if they could show this makes people in this area, the weight of their vote basically 0 or 0.25 as compared to these lines make these voters' votes worth 1.25. I don't know if it gets that sophisticated, but if they can prove vote dilution, that a person's vote is actually weighted differently due to the lines that have been drawn, does the rationale of the malapportionment cases carry over or no?
No, I think the plaintiffs could prove everything in their complaint and more, and we'd be right back here arguing the same question, that doesn't state a cognizable claim within this court's power to adjudicate, at least as pled with the 4 or 5 constitutional provisions they've adverted to. As you've articulated it, I think you're actually getting at one of the problems in this case, which is the rights at issue are hard to wrap your mind around. The complaint sounds to me like a group right and not an individual right. And if you look, for example, at paragraph 234 of their complaint, which is in the record at page 65, the plaintiffs describe the map as achieving a partisan advantage for Republicans by subordinating traditional redistricting criteria. Or in paragraph 209 in the record at page 46, that the map maintains a durable Republican majority. That to me sounds very different than the individual rights that the court is adjudicating in both a malapportionment case, numerical malapportionment case, and a racial gerrymandering case. In the malapportionment case, you should think it's a theory of representation problem that extends only so far as to numerical malapportionment, which objectively by number, someone has less of a voice. It's an objective test. It's based on U.S. Census data. In the racial gerrymandering case, the harm is the individual harm that has been recognized since the Civil War of sorting someone on the basis of race. And there's no way, given this country's history, that you could equate those two things. The other issue that your question is getting at is, I think what this court recognized most recently in the Cook versus Bell case in paragraph 34, where the the court seems sensitive to the idea of equating political speech with political success because the latter feels awfully hard to adjudicate. Redistricting is a zero-sum game. So unlike a malapportionment case where you can resolve the malapportionment case without harming another voter, in a partisan gerrymandering case, as soon as you move Democrats in or take Democrats out, you're harming other voters. You're harming voters who don't want to ascribe to the political parties. You're arguably harming Republicans. And I don't see how plaintiffs can succeed here without having many other plaintiffs line up at the courthouse doors and saying, I want a new map for my issue or for my preferred candidate or for my party.
Well, malapportionment, fixing that did hurt other voters because they had sort of a super vote in some areas and in some they didn't. It put them all at one.
It put them all at one in the way, like, of the leveling out that the Uniform Operations Clause requires, both for malapportionment and for racial gerrymandering. As to your predictability point, I just want to make 3 responses, which is, I still think there's not a cognizable claim here. There's not a justiciable claim, or it's a political question, even if we could prove with 100% certainty who the plaintiffs were likely to vote for in future elections. But I do want to point out in the Veith case, the theory of the Veith case was that there was a cemented Republican gerrymander and Democrats would never regain control. And 2 years later, after that case was decided, Democrats flipped 4 of Pennsylvania's 19 House seats, contrary to all the predictions in that case. And even if you think the technology's gotten better since Veith, you still have to account for the more than 500,000 independent and third-party voters in Utah, where it would be supremely unfair, or at least a political decision, to decide how to count those voters based on their past votes when their actual political affiliation is, I don't want to be affiliated with any majority party. I also don't know how you count split-ticket voters who liked Joe Biden for president, but their incumbent Republican senator and on down. And last, your question raises yet another question, which is why just the major political parties? Nowhere in the state and federal constitution do we give primacy to the Republican Party or the Democratic Party. George Washington in his farewell address said, how dangerous might that be? And then look to the Utah Constitution. The only places in the Utah Constitution that talk about political neutrality are not in Article 9. The Utah Constitution affirmatively says when they want political neutrality, in Article 10, for example, passed at the same time as Article 9, and then more recently with respect to this court, for another example, in Article 8, that says your membership on the court is to be judged by your fitness and not your political views. The absence of that language is really stark and is a cautionary tale for why the court should stay out of the political thicket of redistricting. And that's one more point. There's no way to take politics, small p, big P, out of redistricting. The decision to shift a line here or there, again, not just for the congressional districts, but also for the state legislative districts, is a political one.
But why is that true? Why isn't the answer to just not consider past votes, party affiliation, any of that at all? Why isn't it just to apply neutral redistricting standards that don't take any partisan considerations into account one way or the other?
Because that's contrary to the assignment of redistricting to the political branch by both the state constitution and the federal constitution. The Supreme Court spent 40 years explaining why the amount of permissible partisanship just can't possibly be zero in redistricting, otherwise the constitutions would have assigned it to another authority. And I think here that's why the plaintiffs have conceded. They don't even argue that the permissible amount is zero. And as to your question about neutral criteria, those neutral criteria are helpful in redistricting, but they're not constitutionally mandated. They're nowhere in the text of the present day Article 9. And I think it's not within this court's power to tell the legislature that they must, for example, pass a certain compactness test, or that they must do this or that with districts if it's going beyond what the text of Article 9 says, which is, I think there's enough there to say they have to be perfectly apportioned by reference to the enumeration. And then the text also says that the legislature shall divide the state by districts, which suggests to you maybe some other limitations. They aren't substantive, though.
So if though the plaintiffs were to prevail on Claim 5 and Proposition 4 were reinstated, then that would provide that partisan gerrymandering cannot be taken into account, or partisan affiliation. It would provide neutral redistricting standards. So I'm trying to understand your argument, and I'm not sure that this issue is actually before us, but your argument that Proposition 4 would be unconstitutional under Article 9. My understanding from reading Proposition 4 is that the legislature still gets to decide which maps to adopt. They can even reject all the maps as long as they can articulate a reason for doing so. So how does Proposition 4 run afoul of placing the redistricting authority in the legislature under Article 9?
Well, the law at the time right now is not Proposition 4, it's SB 200, and our more moderate position all along has been you just take SB 200 as you find it, because that's a manifestation of the legislature's co-equal power. If you thought instead that the legislature couldn't amend, again, by a near unanimous vote of the legislature, what the people did through Proposition 4, if you think that the legislature couldn't constitutionally do that through SB 200 in the same way they did for the Medical Cannabis Act and the same way they did for the Medicaid Expansion Act, all passed at the same time.
Yes, but that is my hypothetical.
Right.
They prevail on Article 4, they prevail on Claim 5, Proposition 4 goes back into account. Are you, or into effect? Are you saying Proposition 4 is unconstitutional under Section 9?
I think that raises serious constitutional questions that the court could avoid here, and if you think you have to decide it, then we should be allowed the opportunity to provide supplemental briefing on that question. But as the court has said in Sevier and other cases, as a general matter, the initiative process, just like the legislature's legislative process, just like this court's judicial power, just like the executive's executive power, has to work within the confines of the separation of powers. And that's the separation of powers created at the time of the founding, amended in 1900, but not amended to say that the initiative has the last word. If the people wanted to do that in 1900, they would have used the same text that the people in Arizona did or in other states, and they didn't. So there would be a very serious constitutional question, yes, if you think that the legislature can't do through SB 200 what it has done for other initiatives. And we would want the opportunity to brief that question, because I don't see how through a statute the people can cabin or change the authority given to the legislature by constitutional amendment. I don't think anyone would argue that the people by statute could say that this court's judicial power requires unanimous decisions.
But wouldn't that issue have to be raised in a separate lawsuit brought by the legislature challenging the constitutionality of Proposition 4?
I don't see why the legislature would have to bring a lawsuit challenging the constitutionality of Proposition 4, because the legislature has, I suppose the way it would be raised is the legislature has these pre-existing set of maps. They pass them pursuant to SB 200 and all other state laws and its constitutional authority. And to the extent that the argument is that SB 4 is the Proposition 4 is the prevailing law, which is not the argument here, then a separate set of plaintiffs should bring that lawsuit.
Right, I'm sorry, I probably shouldn't have said the legislature. What I meant was that the issue should be brought in a separate lawsuit, because...
Sure.
Okay.
Sure, but again, like the SB 200 is, Proposition 4 as amended in the same way that the court was comfortable in Grant amending the Medical Cannabis Act. It is a manifestation of that co-equal power, and there would be very serious constitutional questions, even on that more moderate issue, to say the legislature can't do anything with respect to initiatives.
Can I follow up and are you through with that one? Yeah, follow up on a response you gave to Justice Hagan. You said that if the people wanted to change the way the initiative power worked, they would have done what Arizona did, if I understood correctly, put language in.
One of many.
Yeah, one of many. Here's the question I have for you. So Utah's the second state to adopt an initiative right. At the time, those other examples didn't exist. The only example they had was South Dakota. South Dakota's language had a clause in it that the voters of Utah chose not to put into the Utah Constitution, right? That's the clause that says this section shall not be construed as to deprive the legislature or any member thereof of the right to propose any measure. The voters chose not to put that in. And so it seems to me that there's at least some argument based on that seemingly deliberate omission that they did not want to reinforce the legislature's right to initiate any legislation. meaning the legislation that would contradict what had just been passed. So why isn't that the lesson to take from what Utah did with respect to other states?
I think it's a good argument, but it doesn't carry the day here. I think that language, and you can see it in the Weissman decision, where the South Dakota courts later parsing that language, it's not hanging its hat on that language, it's hanging its hat on the power of the legislature.
South Dakota didn't, but I'm just saying, if we're trying to understand the original public meaning of the initiative right, it seems like this is fairly powerful, like there's some lesson to be had here. And I'm just wondering if you can suggest a lesson other than the one that I'm inclined to take from it.
The lesson to be had is the rule of construction argument we put in our brief, which is, I'm not aware of any textualism authority that says you can read in to the Utah Constitution a limitation that is not there, especially when it's contrary to what has been historically understood about the legislative power not to bind future legislators, and especially when in the referendum power there are limitations. And so you would think if there's a limitation on the people's referendum power, there might also be a limitation on the legislature's initiative power. Imagine a world where the initiative provision said, except you can't amend because of a 2/3 vote. That's gone. And the absence of, I draw the exact opposite inference from that absence of the language. And again, I think the court can I think count 5 can just be decided on these narrow grounds that the court said it's co-equal, and in Grant didn't question it, and it shouldn't question it here.
There may be a lesson to be taken too in terms of original public meaning analysis from the very nature of the initiative process. I mean, it's kind of founded on the concept that here's an opportunity for the people to act when the legislature won't. And so it doesn't seem inconceivable to me that someone voting to ratify the Utah Constitution might have assumed that if the public acted in that way through the initiative power, that it would be at least in some measure immune from being repealed by the legislature.
That's interesting, Your Honor. I don't know if this is the same lesson or a slightly different lesson that you're taking, but you could imagine a world where, especially in the 1900s, you're concerned about legislatures doing nothing. And that through the initiative power, the people can create positive law, they can create protections within the confines of the Constitution if the legislature won't. I don't think that's mutually exclusive with the idea of the legislature and the people might be working back and forth. And I do want to push back a little bit on one thing, which is this idea that the legislature has just overridden what the people have done. Proposition 4 passed by about 6,900 votes. SB 200, which retains important parts of Proposition 4, passed nearly unanimously, not by unelected bureaucrats, not by unelected administrators, but by legislators elected up for re-election again by the people. And that push and pull favors democracy in a way where outsourcing redistricting and frankly putting politics underground instead of in public, in a public hearing, in a public way before the legislators accountable to democracy doesn't. And that gets to one of the points I want to make, and I think I've made it a few times today, it's politics all the way down. Redistricting is all about politics in a small p way and sometimes in a big P way. And the people accountable for that since the founding have been the legislature. And that is the default rule in all the states absent a constitutional amendment, and it is the default rule in the federal Constitution as well. And for the legislature is operating within the confines of that default rule by giving a voice to the commission, by subjecting it to public hearing, but still retaining ultimate responsibility for the redistricting plans. And as to the court's justiciability, that just confirms the political question nature of this case. And the political questions, not legal ones, that this court would be required to decide. In Childers Gray, this court applied the same Baker versus Carr test as the Supreme Court applied in Rucho. And here there are two particular problems under that test that I don't think this court can solve given the current words in the Utah Constitution. The matter of policy decisions in redistricting has been given to another branch, and there are no judicially manageable standards, only political ones, for this court to apply in deciding whether that branch has acted fairly. And it's generally outside the court's judicial power understanding the court does have power of judicial review, it's still outside the court's judicial power to adjudicate those sorts of fairness claims.
Can I ask about that? So I went back and looked at the language, both of Prop 4 and SB 200. I don't see the word fair in any of that. Did I miss it?
No, you didn't miss it, Your Honor. And I'm using it as a shorthand where many people think fair redistricting, and we could have an interesting philosophical debate or theories of representation debate that just illuminates the political nature of this question to decide whether fair is equatable with no politics in redistricting.
But to be clear, I'm not reading it wrong. SB 200 nor Prop 4 ask this court to adjudicate fairness.
It's those laws do not, and that is not the claim presented in the case, though. The claim presented in the case is absolutely not that the legislature failed to comply either with Prop 4 or SB 200. That is not what plaintiffs are litigating here today. Plaintiffs are litigating, it's replete in their complaint that there are too many Republicans in the districts, and that is unfair. That is their claim. It's not a misapplication of the Proposition 4 standards, which I think are lengthy, but don't favor or disfavor political candidates, don't disfavor incumbents, again, which itself is very interesting in terms of the theories of representation debate, whether that's fair, but that's not the claim here. The claim here is that it's within this court's power to redraw the lines, and that it's within this court's power to decide whether a fair district is a 50-50 district in Salt Lake, or a safe district in Salt Lake, or whether a fair district is one that stretches across the entire state, or whether the legislature had, quote, legitimate justifications, in the words of their test, to decide that the best way to represent the people of Utah in Congress was to take the most densely populated parts of Utah across along the Wasatch Front and put them into 4 different districts. There's nothing in Article 9, and in some ways there's really nothing in state law to say whether that's whether within this court's authority that's what the legislature should have done. It's a discretionary decision, it's not an unconstitutional one.
Thank you, counsel.
Good morning, Your Honor. I wonder if either I or the court may want a 5-minute break, if that would be acceptable.
Certainly, let's do that.
Everyone in the audience is like, thank you.
court to do several extreme things. They asked the court to hold that the Utah Constitution says nothing about whether or not it is permissible for the legislature to engage in vote dilution on the basis of Utahns' political viewpoints. Then they asked the court to conclude that the Constitution says nothing about whether the people can exercise their right under Article 1, Section 2 to have the inherent right to that all political power is inherent in the people, and that to put that in force, they have the right to alter and reform their government. And not only does the legislature ask this court to hold that that question is non-justiciable, along with all the other claims in the case, but that the legislature has that ultimate right, that all political power is inherent in the legislature, and the legislature has the right to alter and reform the government. That is the opposite of what the Constitution says. Now, I want to build off of a hypothetical that Justice Pierce asked, and ask the court to imagine this. A statute passed by the legislature that says the congressional districts in Utah must be configured such that no more than 36% of the voters in each district cast their ballots for the Democratic candidate in the last presidential election. I don't think there's anyone in this room who would think that that law would pass constitutional muster. It is a content-based restriction on voter speech, and it operates non-uniformly in how it treats voters across Utah. That is precisely what the map that is being challenged in this case does. As the Gallivan Court has made clear, the focus of the equal protection, the Uniform Operation Clause here is on the operation of the law and whether or not it's neutral on its face, and that's exactly what the law here does. And the legislature cannot do indirectly what it cannot do directly. And that, I would submit, sort of concretizes the claims at issue in this case.
Here's my biggest concern, especially on the justiciability issue. The Supreme Court has said the reason that federal courts can't adjudicate these claims is because they don't have any standards. And since that time, you've cited us to many state courts that have adjudicated these claims. But as far as I can tell, every single one of them either has constitutional language or statutory language that either bans partisan gerrymandering or at least sets out neutral redistricting criteria. I think the only exception was North Carolina, which of course vacated that opinion. So would we be the first state court in the country to adjudicate partisan gerrymandering claims without redistricting standards either in our Constitution or in statute?
Well, first I would say, Your Honor, that the Pennsylvania Supreme Court obviously centered its claim in the free elections clause provision, which is nearly equal to what we have here in Utah.
But even that court, I mean, there are standard, I believe, compactness and those sorts of things that they were able to say, okay, we can look at a map that uses those neutral redistricting standards, compare that against the legislature's map, and determine if this is an extreme outlier. We don't even have that here, do we?
Well, the legislature actually did, in its committee process, adopt standards in this instance, and the two of them that dealt the most with what we would consider traditional districting principles were compactness and contiguity, though they did have a number of other background legal principle standards. But I would say the Pennsylvania Supreme Court, after the League of Women Voters case, in this most recent redistricting round in the Chapman case, said, yes, those neutral principles give us some guideposts as to whether or not there's been a violation of the free elections clause. But in addition to that, it's possible, as the justices have noted, that with modern technology, you can draw, reasonable-looking districts that, in fact, are motivated and have the effect of being partisan gerrymanders. And so we can look to more than just those standards. And so I don't think this court would be breaking new ground from the host of other courts that have looked at this problem and said, this is manageable. We can apply our traditional standards for adjudicating these constitutional claims, acknowledging that there might be close cases, acknowledging that the facts will vary from case to case. But as judges, what we do is adjudicate some level of uncertainty and look to the standards that guide the court in doing that. And so I don't think that this court would be breaking new ground. In fact, it would be following Alaska and Pennsylvania and New York and Maryland. And just last week, the Supreme Court of New Mexico issued an order saying that these claims are justiciable and that it would look to the test applied by Justice Kagan in her dissent in the Rucho case.
And I have not read the New Mexico case. I wasn't aware of that. Do they similarly have standards either in their constitution or in statute that set out neutral redistricting standards?
I am not certain of the answer to that particular question. What I do know is that the test that the court adopted is not in reference to those standards. What the test the court adopted is to look first to see whether the predominant purpose of the plan was to be a partisan gerrymander, to look to see if it has that effect, substantial effect, and then whether or not there are legitimate government purposes that might explain it. And I guess the point I would make about that, and Ms. Meehan said that in the racial gerrymandering context that the standard is 0. And that's just not right. There are a couple different branches of racial redistricting cases. There's intentional racial discrimination, and counsel is correct. In that instance, no amount of intentional racial discrimination is permissible. But there's a separate branch of cases, the racial gerrymandering cases, the Shaw v. Reno line of cases. And in that instance, the court is accepting that the purpose that race was used for might not have been to harm anyone. It might have been to help folks in the courts or in the legislature's view. But the test there is whether or not the predominant purpose is the use of race. And the court says we show that by looking to see whether the use of race has subordinated traditional districting principles to racial considerations. Now, if that is a manageable standard to determine whether or not there has been an unlawful excess use of race, then I don't think there's any argument that the proposal that partisan gerrymandering be justiciable does not provide manageable standards. Just as courts can look to the circumstantial evidence of the shape and design of the map, they can look to see whether city and county lines have been split, they can look to see if there's direct evidence. That is the basic thing that courts do. And if courts can adjudicate it in the racial gerrymandering context, there is no principled reason to say why they couldn't do so in the partisan gerrymandering context. The only argument in opposition to that is to reject the premise that the court should be determining whether or not there has been an unlawful amount of partisanship. But the question on justiciability is, accept the premise that it's unlawful. Can we find a standard to do it? And if the court applied that standard in racial gerrymandering cases, it is just not a sensible argument to say they couldn't do so in the partisan context.
You know, that is an interesting argument on racial gerrymandering, and it's certainly Justice Roberts didn't see it that way in Rucho. He saw it as categorical. Mm-hmm. So what do we do with that?
I think that Justice Kagan got it right and Chief Justice Roberts respectfully got it wrong. If you look at there's one paragraph that addresses this issue, and it simply does what I just said. It rejects the premise that we should be looking to see whether there's an unlawful amount of partisanship. And so if the source of law, in this instance, the Utah Constitution, or we would say Proposition 4, which we would ask this court to put back into effect, if the source of law is saying that the use of partisanship violates provisions such as the Free Elections Clause or the Uniform Operations Clause, the question is just, are there manageable standards? And so I think the Supreme Court majority conflated those two issues and merged the merits into the manageability question.
So what provision of the Utah Constitution would you have us weld that standard onto? Because I take your point that that seems to be a manageable standard, but how do we tie it to the Utah Constitution?
Well, the Uniform Operations Clause obviously is a broader protection than the federal equal protection standard. And so in the racial gerrymandering context, it's an equal protection claim. I think, however, the Supreme Court there acknowledged that it was departing a bit from its regular equal protection jurisprudence in the racial gerrymandering context, because it's acknowledging that in redistricting, legislators will always be aware of race. Race can be used in redistricting for recognizing communities of interest and whatnot. It just can't be the predominant purpose. And so I would say it doesn't, because the Utah Constitution is more protective of rights, putting a purpose requirement onto the uniform operations provision would be, discordant with the court's precedent. I don't think that should be a reason not to prohibit partisan gerrymandering. In fact, the opposite. But I think that the court could, if it wanted to use that standard, it could put that into the free elections clause provision, which obviously this court has not articulated as yet the particular standard for. But in the partisan gerrymandering context, that surely would be a reasonable standard to apply to the free elections clause when determining whether there's been an unlawful amount of partisan gerrymandering.
I guess the concern there is just finding a meaning of the free elections clause that would be understood to have prohibited any amount of gerrymandering, given what was going on in the country at the time and the way we see the legislature operate, in early statehood. It seems like that might be a heavy lift. So why do you think it is that the Utah Constitution's free election clause prohibits any sort of gerrymandering?
And I'm not saying that if the court adopted that standard, it would. The question would be whether it was the predominant purpose. And, it's not just partisanship in terms of using a blue and red shaded map while you're drawing the lines. There's partisan considerations in terms of, does this incumbent live in this district? And would we prefer to have this candidate live here? Like, that might not rise to the level of predominance, and in the racial gerrymandering context, I don't think it would. I think Justice Peterson is correct that if the court puts back into place Proposition 4, it's very clear that the people of Utah wanted zero partisanship to be in effect in the drawing of the lines. And then they wanted to be sure that there wasn't accidentally a partisan gerrymander giving too much or undue influence, I think, to an incumbent or a political party.
Counsel, if I could follow up on Justice Pierce's question. What weight should we assign to the fact that the framers consciously elected not to use the term fair, free and fair elections, notwithstanding the fact that other states had included that language? And take that together with Justice Pierce's point that racial gerrymandering was kind of a known evil at the time, and certainly prevalent, and certainly the framers were capable of addressing it explicitly should they have wanted to do so. Yet not only did they not address the issue explicitly, they consciously omitted the term fair from the free election clause.
So I think the court shouldn't read much, if anything, of it. And I think the term is equal is what was used in some of the other provisions.
Thank you for that correction.
And the reason I think the court shouldn't read much into that is because if you look to the Constitutional Convention, just I think days before this provision was adopted, the phrase "and equal" was struck from another provision, and there's discussion about how that would be superfluous because the concept of freedom includes equality, and the same thing was then would carry over to this provision. And if we look to Pennsylvania, where there is a free and equal election clause, the court there recognized that it wasn't always the case that it had that at the founding it was free election, and the court understood that provision to always have prohibited partisan gerrymandering.
So they struck it on redundancy.
Exactly. And with respect to the fact that there's not an explicit provision in the Constitution, I think this is a constitution, and so it is unusual to be dictating and requiring and prohibiting very specific items. Some states have very specific constitutions. I think Alabama's constitution is like 110 pages or something. That is not the Utah Constitution. It's
Some
not
aspects of our Constitution are pretty specific. right down to fishing.
And over time we have gotten more specific. But I think looking at the history, what we see is, and we cite these and we attach them to the briefs, a host of public understanding of the evil of gerrymandering happening. And I don't want to meander too far from your question, but and counsel says that these are all malapportionment cases. Malapportionment was partisan gerrymandering. That is how partisan gerrymandering occurred. That is what the newspaper articles that were published at the time of the founding refer to the problem. They refer to it as partisan gerrymandering, as one party giving itself more power than the other party and manipulating the lines to achieve that. And so malapportionment is vote dilution. Now, technology has gotten better, and vote dilution can happen even if you have equality in the number of people in the districts. And here's another point where I would ask the court to refer to guidance from federal law. Section 2 of the Voting Rights Act. There are equally populated districts. The Alabama case that just happened a couple weeks ago, the Allen versus Milligan case. No one contested that the Alabama congressional districts were equally populated. But what the Voting Rights Act says is that if they have a discriminatory effect by packing or cracking minority voters in a way that they are elected to fewer seats than they might otherwise have an equal opportunity to, then that's unlawful. And so this idea that there's equality so long as there are an equal number of people is discordant with both what people understood at the time of Utah's founding and what the law recognizes today.
Can you help me understand why it is you believe that would be inconsistent with what people understood? I mean, as we try to articulate what principle is embodied in the Free Elections Clause, it's hard to not do it in a way that's circular. And so I'm wondering what specifically you have in mind, because, I mean, my review of the historical record is such that I don't know who said, everybody talks about the weather, but nobody does anything about it. I mean, the partisan gerrymandering falls in sort of the same category, right? There's a lot of talk about it, but no explicit reference to it, no attempt to take it head on. So what are you seeing at the time of the founding of the Utah Constitution that would cause you to believe that people would have understood that the Free Elections Clause was to protect against partisan gerrymandering?
I think it's because you see there's the Wisconsin case at the time, the Indiana case, I think the Michigan case, and these were all discussed widely in Utah at the time of founding in the press. And what was understood there is, this is fantastic. Courts in these states are remedying the ill of partisan gerrymandering. Now, of course, it's happening, the way it was done was by numerical means. But courts are remedying that. And so here we have the Utah Constitution, where the people made all political power inherent in them and provided them the right to alter the Constitution. We have elections shall be free, and I think if you look at the original public meaning of those words, as we do in the brief, freedom is to be free from manipulation and tyranny and despotic governmental power, and elections refer to the process of being elected. Against the backdrop of the public discourse around partisan gerrymandering, I think it would be unnatural to read it as the legislature proposes, which is just, you have the right to cast your ballot.
See, I'm not sure which way that cuts. The fact that it was an issue that was being addressed by states, the issue of partisan gerrymandering. I take your point that we're typically looking to principles in constitutions. They're not necessarily specific, but as to voting rights, we got an age, 18, as opposed to mature enough to vote. There's a reference to soldiers voting and so forth. I mean, it just seems like low-hanging fruit, so to speak. Had the legislature, the framers, wanted to address this rather prevalent problem in the voting context, that they could have done it. Maybe you've already answered that, and you've given me a good answer, but if there's anything you can add, and I'll broaden it. I have the same question Justice Pierce had. I'm looking for any indicia, any evidence of what voters might have understood when they cast that ratification vote.
So I think I want to give an example that I think illustrates the answer. There's nothing in the Constitution that says that districts have to be equally populated. That would be a very clear-cut, easy thing, low-hanging fruit, to say that in the Constitution. But no one said that. And this court, courts across the country, the U.S. Supreme Court, and I think this court and Gallivan, essentially, held that the Uniform Operation Clause requires that numerical equality. And I think the same argument, if adopted, would mean that the court was wrong about that because at the founding no one said you have to have equally populated districts, therefore it's off the limits in terms of a topic that can be protected by the Constitution.
You know, I do take that point, and I see how that's a better fit, but where we have a number of clauses that go specifically to elections, you know, I wonder how to reconcile that. I wonder whether we should be looking to another clause when we have these clauses specifically addressed to elections. Should I be thinking about it in that way, or what's the error in that?
By specific clauses, are you referring to the four clauses?
The election clause, the qualifications, voter qualification clause, let's say.
I think
the
what,
election section.
right. I think what the court should infer from that is that this topic was extraordinarily important to the people, and they wanted to ensure that they were creating broad principles that would capture all possible ills that the legislature might choose to bring upon them, particularly given the Utah context where there was such concern about ensuring that the legislature did not take more power from the people than what they wanted to allocate to it. And so I would take the opposite from that, which is look at the breadth of these protections and don't interpret them narrowly and require some unique specificity in this context that wouldn't arise elsewhere. I want to say with respect to the Article 9 argument, in particular with respect to its effect on Proposition 4, I don't think this is an argument that was raised, but I would refer the court to the U.S. Supreme Court's understanding of this type of provision, the Lawyer versus Department of Justice case, which looked to the Florida Constitution, which has an essentially identical provision that says that after the decennial census, the legislature of Florida shall convene and pass a redistricting map. Obviously, that's not exactly what it says, but that's in effect. And the U.S. Supreme Court, responding to an argument by the parties and by the dissent, contending that this placed the exclusive power to redistrict in the legislature's hands and courts couldn't adjudicate claims about it, said, no, all this provision means is that we need someone to redistrict. And so we need to ensure that happens. And so in the first instance, it is the legislature who has to do that. The people could do it too, but the legislature has to so that we have a map. And the Supreme Court said that is not somehow stripping the other branches of government of their normal power, the courts to adjudicate whether the law that was enacted is lawful. And so Article 9 does nothing more than that. And to interpret it to require that the legislature is the sole power on this would add words to the provision and would be contrary to both common sense and how the U.S. Supreme Court has
Does it matter that Article 9 says legislature as opposed to legislative power?
No, I don't think so, Your Honor. And the reason is just that all this is doing is saying that we need someone to do this. And so we need to ensure that some entity of government, some exercise of legislative power occurs so that there is a new map. This is unlike other areas of the law, right? Like there has to be a law. And so in essence, this is actually a limitation on the legislature's power. For a long time, the legislature just didn't pass apportionment plans. And that that was in violation of this. But the idea is that we need to ensure that a map exists. And I think that provision does nothing more than assign that task so that the legislature does it. It doesn't mean that it somehow is not a legislative function that wouldn't also accord to the people under this court's understanding in the Lehigh City case, that it is a legislative function that both the people and the legislature have because it's...
But if the people do it, as I understand your argument, it's permanent unless the people by initiative decide to change it. I mean, I think you can see the legislature could make technical amendments to Proposition 4, but I don't understand Proposition 4, at least under your argument, to have an expiration date. It is, I mean, they call it a kind of super law almost beyond a constitutional amendment. Is there a way you can cabin that, consistent with your argument?
And the point that Your Honor just made, that I think I took the point to mean that if the people passed a redistricting plan, that it might continue into perpetuity because the legislature cannot repeal
Yeah, I
it.
think that's how I understood your argument. That Proposition 4 cannot be repealed by the legislature ever. Or are you arguing something else? Could not be repealed within a reasonable time. Could not be repealed relative to this census. Or is there some point at which the legislature could do something?
Well, I want to be clear that Proposition 4, of course, does not put a map into place. And I think that if the people were to pass a map through their initiative power, that's where Article 9 would say, okay, the legislature and the next decennial census has to pass a new plan, and that would not make that some sort of like super legislative initiative plan that passed. But with respect to the repeal of Proposition 4, I think that yes, the legislature cannot repeal an initiative passed by the people, and I think there's a number of sources for that. One is as Justice Pierce mentioned, the fact that in the context, the provision in South Dakota was removed. And I think you have to look at that deliberate choice. This is the only example that Utah had. They removed the one provision that made clear that the legislature could come back and do what it wanted to exercise its legislative power. So then we need to look at the backdrop of the Utah Constitution, which the most important one is Article 1, Section 2, that all political power is inherent in the people, not in the legislature, in the people. And so we have to read that consistent with Article 6, which assigns the legislative power. And Article 6 is a very carefully balanced distribution of that power to ensure that the people are actually primary. And this court has recognized in the Lehigh City case, and I think it's footnote 10, that in some instances the people's legislative power is actually superior to the legislature's, and Justice Larson's concurrence in the Utah Power case. And if we look at how that provision in Article 6 is set up, it specifies that the people have a veto essentially over what the legislature passes. And then it speaks very clearly about what the legislature can do with respect to initiatives. It is an affirmative grant of power to regulate the conditions and the procedures and other aspects of effectuating the initiative process. And what this court has said in its cases is that the legislature can't, inherent in those words is the concept that the legislature cannot unduly burden or defeat the purpose of the initiative in conducting those regulations.
And it does sound to me like the legislature can never do that. If I understand your argument correctly, that Proposition 4 provides a mechanism for selecting maps, which will continue in perpetuity, absent some modification, at least in its core purpose, absent some modification by a subsequent initiative.
Yes, or absent, the legislature, of course, has the power to initiate a constitutional amendment. And so if the legislature thinks there's something wrong with the people's choice, then of course the legislature can propose to the people an amendment. And that's the back and forth of the Constitution, of the democratic process, the ping pong that the document envisions.
I suppose it could work that way, although I'm not convinced that the people at the time of enacting this amendment ever thought that's the way it was going to work, and that the legislature would never have the ability to modify legislation that was passed by initiative, that you'd have these little chunks in the code that could only be taken out by a subsequent initiative, whether it was initiated by the legislature or not. I'm wondering, normally when we talk about infringement of rights, we don't talk about it in such absolute terms. I mean, I wonder if part of the answer to this is that, the legislature can make changes as long as it passes some degree of scrutiny, whatever the proper degree of scrutiny is. And so if it's something that touches on the right to alter or reform government, perhaps that's a legislative change is subject to heightened scrutiny. If, on the other hand, it's a technical cleanup, it might just be rational basis. The legislature needs to come in and say, no, there's a reason we did this, this won't function. What's your reaction to that sort of framework?
I'm nodding my head. I think that would be a perfectly sensible application of the law to that. And you know, of course, I think there's sort of a boogeyman raised that, well, if something is a technical error, was written wrong, and we're arguing that you could never change that. I think the court could read into the fact that the legislature has affirmatively granted the power to have conditions on the initiative, that one of those conditions can be if you screw it up and it doesn't work, you know, we can amend it to fix that. And
I agree that's an extra textual sort of limitation, right? Because as I read the Constitution, at least, where the legislature has a role, at least where the people contemplated it, it would just be to enact a framework to put the initiative on the ballot.
Right.
And it's pretty quiet about what the legislature can do afterwards, and we're trying to interpret that silence.
And I think that is how this court has, that's all this court's been faced with, is those sort of enactment questions about the initiative. But I think that Your Honor's point about looking at what the legislature has done, to assume they have some sort of inherent legislative power to do something with this, I think the fact that it was so carefully worded to grant them affirmatively just that procedural power, to grant themselves the power to say no to what the legislature has done, in the backdrop of this principle that the people have the right to alter and reform their government, I think that to the extent the legislature has any power to undo initiatives, it has to be through some sort of heightened scrutiny framework like what you have suggested. And at its apex, when what the initiative is one that alters and reforms the government. Because if the legislature's argument is correct, then that is meaningless. That the initiative power is illusory and completely superfluous. Why would we spend so much time saying that the legislature can't dictate what the topic of the initiative is going to be? It can't dictate how many counties can get signatures. It has to be sacrosanct. Courts have to be inviolate for this right. If what actually they could have done all along is just repealed every initiative. And then I heard counsel today argue that if they do so by a 2/3 vote, that means that the people, that's done, that there's no more power in the people to regulate and alter and reform their government on this topic because the legislature passed a repeal by 2/3. Now, that's different than what the legislature argued in their brief. At pages 18 and 19 in their brief, the legislature argued, well, the solution is for the people just to come back and pass Prop 4 again. I don't think that's a solution either, because it's quite evident that the legislature would repeal that.
Can I walk you through a hypothetical based on what Justice Pierce said? So in this case, one of the examples that the legislature has pointed to is removing the Chief Justice from the process, not from judicial review, but from the process of appointing commissioners or selecting maps. And their justification for that is that kind of provision would violate separation of powers. So I suppose if the citizens were to challenge that in court, first we'd have to determine, is that an amendment that touches on what's arguably the fundamental right to alter or reform your government? And if it is, then the legislature would have to satisfy strict scrutiny. They'd have to show a compelling government interest and that it was narrowly tailored, which I am assuming they would submit. They could meet that test. Is that the kind of process that you're envisioning? Is that it's not that they can't amend an initiative, but if they do so, they then have to meet whatever level of scrutiny is appropriate based on the nature of the amendment?
That I take to be what Justice Pierce was suggesting, and I think that would be I think your hypothetical assumed that the claim was that the involvement of the Chief Justice violated the separation of powers provision. I don't think that claim would have to run through that course because there's a separate constitutional violation that's alleged. Now, I don't think that is correct. I don't think that provision violates the separation of powers. Obviously, this is sort of a side issue, but I think whether or not the Chief Justice is choosing whether or not the law is being followed, that's certainly not exercising any legislative power. And I think the argument that was made is not that it would be the Chief Justice exercising legislative power, but that it would be issuing an advisory opinion. But if the court were called, the whole court were called upon to make this claim, perhaps that would be an argument. But just using a government official to do something within that branch's purview, that wouldn't be an advisory opinion.
But apart from the merits, is that the framework we'd go through? That if the legislature were to amend a provision of Proposition 4, let's say you prevail on Claim 5. Proposition 4, it goes back through proceedings at the district court, you prevail. It goes back into effect. Is your position that the legislature can amend portions of Proposition 4 so long as they satisfy whatever level of scrutiny is appropriate based on whether what they're amending touches on a fundamental right or not?
I think that to the extent that there are amendments, they need to be in furtherance of the initiative. And so one example that we provide in the brief is that the private cause of action, that could be amended to require that that be heard by a panel of 3 judges with direct appeal to this court. And that would be furthering the purpose. So to the extent we were layering on levels of scrutiny to that, which I think would be appropriate given the fundamental nature of this right, then you would just layer those levels of scrutiny onto whether or not the legitimate government purpose that it is in furtherance of the initiative. And that would be consistent with this court's case law on the front end about what types of procedures can be regulated by the legislature and whether the initiative can go on the ballot in the first place.
Can I follow on to that question? So here, what specifically are you asking with regard to count 5? So the district court dismissed it. You've asserted that there are 2 rights involved, the right to initiative under Article 6, and then the right to alter or reform your government under Article 1.2. So rights are involved. You're saying that SB 200 impinged upon those rights. And normally, we don't just say, yes, you're right, it affected those rights, and now Prop 4 is back in place. Usually, we apply heightened scrutiny. So in this case, hypothetically, if we were to agree with your argument that SB 200 did impact the right to alter or reform your government, what would be the next step?
I think under the heightened scrutiny analysis, the court would look to see whether or not there was a compelling government interest that was advanced for what it did. I think we satisfy the fact that there's been a violation of the rights, right? And so I guess the argument would be the legislature has the right to engage in partisan gerrymandering. That was the compelling justification for repealing the ban on partisan gerrymandering, for repealing the traditional criteria, repealing the cause of action. And so the court would look to see whether it satisfies heightened scrutiny in furthering some compelling government purpose.
Is that something that we would do on this appeal? Is that something that would be remanded to the district court?
I think the issues are before the court. I think the court could remand it to the district court. And the way I see this is entirely a legal argument. There are not facts that are relevant to this. So there's not necessarily fact-finding that the district court would need to engage in.
Have the parties argued this, though? Has anyone argued about heightened scrutiny for these rights?
No, I think the first time I've heard this is Justice Pierce's question earlier today. But we have argued the fact that these are fundamental rights, and that certainly that heightened scrutiny applies across the board to all of these claims. But this framework of what do you do when the legislature repeals a government reform effort? Of course, this is the first time this has ever happened. There have been 7 initiatives. This is the first time the government's repealed.
Probably unlikely the government would advance, we want a gerrymander in a partisan way as their compelling interest.
It wouldn't be a compelling one.
It would likely be, we want rural and urban interests represented by each congressperson.
But I don't think that would be
others that they would come, but it hasn't been argued, and it does seem like an important question. So what do we do with that?
I think the court could ask for a supplemental briefing on that question. I think that the court could remand it for the district court to address in the context of allowing a trial to go forward. But I do think that it is certainly an issue that this court can address. But I don't think that the legitimate purpose for repealing Prop 4 can be that the legislature wants an urban and rural mix in districts. The legislature could try to, under Prop 4, what they would do is they would say, okay, we've got one map that the purpose of which was to have an urban and rural mix. That was the SH2 map that the commission proposed. And the legislature would say, okay, here are the reasons we're rejecting that map because our map better complies with the criteria. And so I don't think they could advance that as a justification for repealing Prop 4.
Could they, on specific provisions, could the legislature argue, well, we took the Chief Justice out of the process because we thought that would be a constitutional violation of, you know, it would require an advisory opinion, so that's why we did that, and then the district court could adjudicate that?
I think that would, so certainly that wouldn't mean that Proposition 4 could be repealed in its entirety. I think the suggestion that that's why Proposition 4 was repealed is belied by the fact that not only that provision was repealed, but every other provision was repealed. And so certainly there are opportunities for the legislature or an individual who wants to make this claim to assert that the text's involvement of the Chief Justice is improper, and there's a severability provision that would allow for that particular provision not to go into effect. None of that, of course, is before the court here in this case. And so I think, as Your Honor noted earlier, that would need to come up in some other proceeding, another lawsuit or a further proceeding.
If I understood Justice Peterson's correctly, I think there's a presumption, probably a correct one, that this initiative, Prop 4, would be seen as one to alter and reform government, and therefore heightened scrutiny would apply under kind of what we're batting around hypothetically. How do we know when Article 1, Section 2 is triggered? Because on some level, every initiative alters and reforms government, right? I mean, medical cannabis altered and reformed government. So do we read in the structure of government and say that's implied in there? How do we know when an initiative alters and reforms its government within the meaning of Article 1, Section 2?
I think, Your Honor, you got it exactly right with respect to the structure of government. So the medical cannabis provisions pass laws similar to what the legislature would pass, an ordinary legislation. It didn't create new powers or take powers away within the constitutional structure. It didn't create a new commission that was meant to be a backstop on the conflict of interest of the legislature. And it didn't, and so in that respect, I don't think there's a strong argument that that law, that initiative was an alteration or reform of the structure of government. I think that's the closest we probably can get to a bright line test. Is it altering the structure and the powers of government?
Sorry, I was just going to say, textually, how do we get there, looking at the language of Article 1, Section 2?
Well, I think that's inherent in the idea of reforming and altering the government. I don't think that passing a law that says English is the official language of Utah is reforming the government. It's initiating legislation, exercising the legislative power.
But it might be altering the government, right? I mean, if it's telling government that you can only publish things in English, doesn't that alter government?
I don't think in any fundamental sense. I think it enacts legislation. So I think the question is it going to the substance of what the legislation is, or is it going to what is the framework of government? And short of perhaps the initiative about how we pay sheriffs, the rest of the 7 initiatives have not been on this core structure of government issue. But this one clearly, this is the one that's most clearly is. And to say that the legislature can simply repeal that and to argue that then that's it, that because it was done by a 2/3 vote, that's it, is wholly contrary to both the text and the spirit of Article 1, Section 2, but also this court's cases interpreting the importance of it. And one point I wanted to be sure to make was in their brief, the legislature says multiple times, this is on page 12 of the brief in the Proposition 4 case, that they argue that this is non-justiciable, that actually, well, one, they argue that this clause is not self-executing, and that the question is non-justiciable, which, I mean, no claim has ever been held non-justiciable by this court, and there's an argument that all 5 of them are here. Today, for the first time, this court should say 5 things are non-justiciable. But what the quote from the brief I wanted to raise with the court is that deciding this claim, deciding our claim 5, would put this court in an impossible position of deciding which of 2 duly enacted pieces of legislation, one by the people through their elected representatives in the legislature, and the other by the people through an initiative, reflects the true will of the people. Now, I would submit that that's an actually very easy question to answer, that the 500,000 plus Utahns who voted by a majority vote to put this proposition into effect is the will of the people, and not the legislature repealing the people's initiative. I don't think that's a grave justiciability concern. I don't think that's a difficult question to answer. And I think that is the fundamental issue in this case is, does the clause that says all political power is inherent in the people and they have the right to alter and reform their government, does that mean what it says? Or does it actually mean that it's all in the hands of the legislature? And the legislature, if it wishes, could reform and alter the government, but if it doesn't want to.
I wonder if it's always that clear a dichotomy, though, because we so often speak of the people acting through the legislature. I mean, here is the people can act legislatively, directly. They can act through their representatives. Go ahead.
Sorry, I think this is probably the clearest case. I think that Your Honor is correct about that. But the clarity, but the fact that there can be more difficult questions in different cases doesn't mean that the court throws up its hands and says, well, there's no precise meaning of this phrase, and though we think it applies here, it might not apply in some future case. And that is particularly so when you look at these 2 claims together, that what has happened here is the legislature has for decades engaged in this anti-democratic distortion of the process. And the people said, we have had enough. We are going to alter and reform our government and recognize that we hold the political power in this state. And we're going to put restrictions. We're going to say 0 partisan gerrymandering in the map drawing. We're going to provide for standards that they should use. And we're going to ensure that the court can enforce those standards after the fact. And to contend that can then just be repealed and that there might be more difficult cases. This is as clear a case as you could get. And if this isn't what Justice Roberts envisioned as the solution, the people getting together and saying, we're going to exercise our power and we're going to stop this, then I can't imagine how his words could have meaning in the Rucho case.
Counsel for the legislature, though, argues that there is still remedy here for the people, right? They can go and unelect these legislators. And so, there's an argument about the ping pong and where it stops, but they said ultimately that's how democracy is supposed to work. If the legislature repeals what they want in an initiative, then the next step is to unelect these legislators. What's your response to that?
Well, and that was exactly, I was trying to think of that as I was trailing on my answer to the Chief Justice's question. Yes, that's the problem with the partisan gerrymander, is that once you get the power once you take the power once from the people, you have it. The legislature has it. They can draw the lines for themselves so that the people, it doesn't matter what the people want.
And here where we're dealing with a congressional map, though, the people would still have the power to come in and unelect these state legislators to get their congressional maps changed. I could see it being a bigger issue if we were talking about a state map being drawn in a way where these legislators were insulating themselves.
Well, the claim in this case right now is that that the congressional plan is an impermissible partisan gerrymander. I don't think the court should read into that it's the plaintiff's position or the facts would show that the map drawn for the state legislature was not a partisan gerrymander, I think.
Fair enough, but do we have those allegations though in front of us, that those state maps reflect a partisan gerrymandering?
No, but Your Honor, I don't think you would need those allegations to make the conclusion that it somehow is okay to repeal Proposition 4 because the people can have their will heard through the election of the legislators. The very purpose of Proposition 4 was to take away the line drawing, the distortion of the line drawing from the legislature and ensure that that doesn't happen. And so I think that's not an answer. And regardless of which claim is before the court, which plan is before the court today, I don't think the answer can be that, well, they can just vote in the next election. That was the whole purpose of enacting Proposition 4 in the first place.
And does Claim 5 go to the entirety of the redistricting maps or just the congressional districts? I mean, if we, did I say Claim 4? Claim 5. If you were to prevail on Claim 5, wouldn't it affect all of the districting lines in Utah?
Yes, in that it would provide the standards for redistricting. As I stand here, I'm not sure whether, I can obviously check this, whether the language applies to local redistricting in Amendment Proposition 4. But if it does, and this was one of the arguments that I heard, that sort of parade of horribles, this is the court's going to be drawn into this, and it's going to be deciding what street goes into what district and whatnot. Just as a sort of reality check, the Salt Lake County has an ordinance that prohibits partisan gerrymandering with respect to the county office. And I think, as everyone recognizes, outside of the Salt Lake metro region, you're not going to have a partisan gerrymandering claim about the St. George local government. Where there is political diversity in the state of Utah is in the place that already separately prohibits partisan gerrymandering with respect to local offices. And so, as a practical matter, the concern that the court is going to be deciding, commission boundaries or council boundaries is just not going to happen. That's not a real concern. But separately, I don't think it's a bad thing to have as a governmental principle that redistricting ought to occur by the standards that the people chose, the traditional neutral standards that don't take into account the partisanship of the voters. And the second sort of parade of horribles argument was that, well, maybe this applies to folks who are Green Party members or who are independent or libertarians. And 2 points on that I would like to make, which is first, that the harm here was accomplished by looking at how people voted in actual elections and trying to stop them from being able to translate those votes into members of Congress. And so it doesn't require looking at party registration data or whether folks are independents, or, as often happens in Utah, folks register as a Republican so that they can have broader say in certain statewide elections. That's not what happens when partisan gerrymandering occurs. They look at past election results. And second, there has to be a redressable, the injury has to be redressable. And so if there are 1,000 members of the Green Party in the state of Utah, they're simply not going to have an injury because you wouldn't be able to draw any sort of district that would ever give the Green Party the possibility of electing a candidate of their choice.
Can I, Justice Hagan, are you finished with that question?
Yes, I guess I was just wondering, I realize that that Proposition 4 doesn't apply to local, but doesn't it apply both to federal congressional seats as well as state?
Yes.
House and Senate seats?
Yes.
Okay, so if you were to prevail, it would affect the map as to all of those potentially?
It potentially could, yes. It would require that the legislature, well, first it would require the legislature to accord real respect to the maps adopted by the commission, unless they had a reasoned explanation for why their proposal better accorded with those principles. But it also would ban partisan gerrymandering in the state legislative plan. It would provide that same cause of action to enforce that as it does with respect to the congressional plan.
Which I suppose goes to your answer to Justice Pullman's question about can't this just be, can't the people affect their will by voting out certain legislators? If Proposition 4 was also intended to apply to those state level districts as well, that might manipulate the election process, I assume is your argument.
Exactly, exactly.
I wanted to ask about the other claims, the claims 1 through 4. Are these claims about group rights or individual rights? And I guess not so much the free elections clause, but the other claims, uniform operation of laws, free speech.
So these are individual rights, but the redistricting context is a little different than most contexts. And I guess what I point the court to, again, is the racial gerrymandering claims. So when you're remedying the violation of these individual rights, obviously these are districts we're drawing. They have hundreds of thousands of people in the context of the congressional district. And so what the federal courts have recognized is, though this is an individual right, we have to recognize the reality that we're drawing districts. And so sometimes it'll be the case, even in cases that I've been involved in under the Voting Rights Act, where you have a plaintiff who's alleging that their voting power has been diluted, either they've been cracked or packed into a district. And when the remedy comes around, say you prevail and there's a remedy, that person might not end up in the remedial district. They might still be in a district that doesn't have the candidate of choice likely to win that they would prefer. But the courts have recognized that we have to be able to, it's both an individual right and like a group action with respect to drawing the lines. And so at the front end, you're making a claim about individual rights, but recognizing that when it's remedied, it is a collective problem. And so I think that at least is how this has been handled with respect to the federal redistricting claims.
I think one of the amicus briefs talked about how gerrymandering has become more sophisticated with the data that is able to be collected now and with programs that are at people's fingertips, and that same information can be used to show whether partisanship was the predominating factor or what explains the maps that are being drawn. Can that data give information about vote dilution?
Yes, absolutely, because what we would do is draw an alternative district and see what was possible, or if we're allowed to go to trial, what we would do immediately with our expert reports is show that of the run of thousands of maps where you would have neutral traditional districting principles, or the built-in political geography of the state, and randomly draw those maps, you would almost never, you would never come up with something as extreme as what the legislature enacted. And you would almost never come up with a 4-0 congressional delegation. And so the tools exist to show both the dilutive effect, as well as just what your eyes show you when you look at the map and the way that Salt Lake County was divided.
Can that be shown, though, on more at the granular voter level? So can that data show individuals in this district with this viewpoint, their vote is worth this much compared to other voters?
I think the way that you would do that is by looking at the vote returns in the precinct and then comparing that to the overall composition of the district you've drawn. So when you sit in the court, if it wants, can go do this on davesredistricting.org and try this out. But you can see as you're drawing a plan, and this is the case in any of the programs, both the individual precinct level or the block level, if you've disaggregated the data to that level, and then you can see, okay, how is the inclusion of these people affecting the overall composition of the district in terms of its political, you have a range of elections that you've reconstituted into those new lines and see how, okay, well, would Senator Romney have won it by this percentage, or would President Biden or Trump have won it by X percentage? And in doing that, you can see the extent to which you are minimizing the voting strength of the disfavored group of people. And that is precisely what happened when you take a cohesive community like Salt Lake County and precisely split it into 4 quadrants, so that, going back to my initial example, you have a plan where the Democratic candidate cannot get more than 36% of the vote. That's the ceiling. That's all they've ever gotten. That's the high water mark, is across all 4 plans. This is what those voters will be able to achieve. And as I said at the outset, I think we all agree that the legislature couldn't pass that law. They also can't pass it through the form of a map and comply with the uniform operations principle.
How does your count 5 coordinate with counts 1 through 4? So if we agreed with you on count 5 that SB 200 impacted the right to alter and reform your government, and that claim was processed through whatever the next step would be, what happens to 1 through 4? Because it seems like your initiative and right to alter and reform the government claims are about the amending or repealing of the initiative. 1 through 4 is about the specific maps.
So I think what would happen is, on remand, we would amend our complaint to add the cause of action, the statutory cause of action challenging the map under the Prop 4 prohibition on partisan gerrymandering, under the Prop 4 standards that the legislature was obligated to apply. And so if the court agrees with us on both of our, both on the counts 1 through 4, affirms the district court in that regard, and reverses on the Prop 4 claim, we would amend the complaint and add those claims.
What happens to the 1 through 4 though? Because the proposition requires a different process, right? And so the maps that are currently in effect haven't gone through that process.
Right.
At least you've alleged that they have not, and that may be disputed, but you've alleged that they weren't voted on, there wasn't a written explanation of why they were rejected, and the standards and the prohibition on partisan gerrymandering was advisory, it wasn't mandatory.
Mm-hmm.
So those would be new rules and a new process that the current maps didn't go through. But you've got these other constitutional claims about those maps. How would that work, and why would the court, if your proposition claim was still alive, would the court even go through your constitutional claims about those maps, or how would that work?
Well, I certainly think that the district court could, so the 2 issues I want to address. I think the district court could apply the principle of constitutional avoidance at that point and say, we have a statutory cause of action and adjudicate that statutory cause of action. And if we were to prevail on that cause of action, then it wouldn't be necessary for the court to reach the constitutional claims. With respect to the process, I think at the moment there is not a challenge that says that, because the law is not in effect. But if Proposition 4 goes back into effect, certainly an additional claim could be, not only does this a partisan gerrymander and doesn't pass the standards, but also, it was unconstitutional to repeal it, the process was wrong, and so it didn't even go through the correct process. That could be an additional claim.
I know it's in your brief, and I'm not asking you to read your brief to me, so please, no,
There's
that's
too
not
many
what
pages of it.
that's not what I'm asking. But the uniform operation of law clause, I'm wondering if you could just, at a very high level, explain to me how the complaint alleged facts that state a cause of action under that provision. What facts have you alleged, and how does that tie to the test?
Well, so one, there's a classification based on how voters cast their ballots. So all voters are supposed to be equal, right? And so some voters were given greater power to translate their votes into elected representation. and the voters were classified on that basis. And second, there is no legitimate justification to say that the legislature prefers Republican voters over Democratic voters. That's not only a violation of treating people not uniformly, but it's also a content-based restriction on casting the ballot. Now, in heightened scrutiny, the legislature...
Before you move on from the classification, what's the classification?
It is subclassifying the class of the voters, and it is subclassifying them based upon how they cast their ballots.
Voters who voted,
It depends on how to some extent it might depend upon how the legislature engaged in the partisan gerrymandering, but voters who voted in past elections, so take, for example, the presidential election. Oftentimes we see in states where the legislature has used the most recent elections because they're the most indicative of the next election, and use those to determine, as I was saying to Justice Peterson, what percentage of folks are we going to put in each district who cast their ballots for that candidate.
so the class might be voters who voted for the Democratic presidential candidate in the last election.
Right, as opposed to voters who cast their ballots for the Republican candidate. And the non-uniform treatment is we're going to make sure that those voters who cast their ballots for the Republican candidate will control the outcome of the election in each of the 4 districts. And so at the heightened scrutiny stage of the analysis, the government would then have to offer some compelling, legitimate government purpose that was furthered by this. What has been offered at this point, I believe, is this rural-urban mix explanation. And there are ways, if we get to trial, at this point we're at a 12B6 station, right? And in the complaint we've alleged that that was a pretextual justification. I think that's all this court needs to conclude at this point. But I think at trial the evidence would prove that point. And one way that courts across the country in redistricting cases in the federal context look to see if you're offering a true justification is to look to see if there's alternative maps that would accomplish that goal without having the discriminatory effect. And here we have one from the commission that comported with the urban-rural mix suggestion by the metrics of the commission better than what was enacted, and that was just disregarded in favor of the gerrymander.
And the hook that gets you heightened scrutiny in this instance is the implication of the fundamental right to vote?
Absolutely. This is
not the nature of the classification?
Right. This is implicating the fundamental right to vote. I believe, the reply brief of the legislature, they suggested that we said that this was a suspect classification, that we are centering this in the fundamental right to vote. And in this case, it's not only, if we look at this case holistically, it's not only the fundamental right to vote in the election, but also the initiative process as well. And all of that together implicates the fundamental right.
If we're looking at equal protection, does that require that we ensure each district is a competitive district?
No, practically, I don't think that you can do that in Utah. But there is one, there's, if you draw a map, if you sit down and try to draw a congressional map of Utah, you have to try very hard to come up with what the legislature achieved here. There are natural groupings of county. The political geography is such that the counties to the north of Salt Lake County compose nearly perfectly the population of a congressional district. And then if you draw a district following natural communities of interest and cities and jurisdictions and counties, you come up with a plan that would not violate any equal rights. And so we're not asking the court to draw the line between fair or competitive or safe or any of that. We're asking the court to ensure that people are not treated non-uniformly in the legislative process. And that's exactly what happened here.
So your claims aren't based on outcomes at all? You're not claiming that it should be weighed at all, whether races would be competitive or there would be some sort of balance in outcomes of elections. It's more looking at lines on the map and what the effects of those are under your various claims.
Yes, and certainly at this stage, we're here on the motion to dismiss, and so this court doesn't need to say anything at this point about remedial issues. But, Proposition 4 itself spoke to this by banning the use of partisan data when the maps were being drawn, which would get to the point of zero, inclusion, but also at the back end ensuring that in the process of doing that, one party or one set of incumbents haven't been given an undue set of power. And so there's some element of ensuring that a facially neutral application of the law doesn't have a non-uniform operation, but certainly that's not an issue that's before the court right now. If the court has no further questions, I will sit down.
Thank you.
Thank you.
Thank you, Your Honor. A few points on rebuttal. I will be as quick as possible, given the time. A few points first on count 5 and the initiative power. We think the district court got it right on count 5 and that should be affirmed. Generally, the legislature's position is a bit more modest than what was stated by my friend, which is that, as this court discussed at length in Carter, and I point the court to paragraph 20, beginning at paragraph 27 in Carter, that the people and the legislature have co-equal and concurrent power. And when Carter's discussing how the people's power might sometimes be superior, that's specific to the lack of the governor's veto over an initiative, whereas when the legislature passes legislation, it has to be vetoed. And to take plaintiffs' argument seriously means that the initiatives take on amendment-like status, even though Article 6 stops short of that. That's a particular problem here, where as a matter of fact, 505,274 Utahns voted against Proposition 4, and plaintiffs' arguments would say that the 512,000 who prevailed get to their rules persist in perpetuity in conflict potentially with the Constitution.
Can I pause you there and just ask you about the standards of review, not standards of review, but the standard that we would apply to, if we were to assume that the legislature has some ability to amend, but it's not unfettered, and that if it touches on a fundamental right, it would have to pass heightened scrutiny, and if not, it might be something closer to rational basis. What's your reaction to that?
I think it has to be rational basis, but it's something I'd want to think more about. There might actually be a temporal way to do this, which is this court already reviews restrictions on the initiative power beforehand, and that's what makes the severe case so important, which it says the legislature can't tie the people's hands beforehand, and the people should be allowed to propose by initiative anything that the legislature could do. To say then that the court's also going to jump in the fray after the fact in a standard which feels to me a little bit like I know it when I see it. I know when the Cannabis Act doesn't go too far, even though the amendments are giving new power in executive officials to grant permits, but these amendments do, and I'd exercise particular caution here where it seems like the political overtones of what's happening with respect to the subject are what's driving it. And that wasn't the case in the Grant case. So I think it's rational basis review, but I also think you just avoid diving into the constitutional morass of figuring out whether the legislature went too far by telling the legislature they can't go too far beforehand. And that brings me back to the, for lack of a better analogy, the ping pong point, which is, as a matter of theory, there's nothing wrong with the two branches ping-ponging back and forth. And as a matter of practice, what the arguments here today are forgetting is that this court isn't the only check on the legislature. The people are too. And I would submit there'd be serious political consequences for the legislators if you get an initiative passed by an overwhelming majority of the people, and then the legislature comes in and says, we don't care. And we shouldn't ignore those political consequences when understanding the clear division of co-equal power in Article 6.
Can I get you to tie that to Article 1, Section 2? So if we're talking about an initiative that goes to an alteration or a reformation of the structure of government, right? And assume with me for a moment that that's what Article 1, Section 2 protects. Right, and the legislature goes in and just amends it on policy grounds. We disagree with that. Why would that not be subject to some sort of heightened scrutiny review?
I don't understand how I agree Article 1, Section 2 is in the Declaration of Rights, and we tend to apply heightened scrutiny. The problem with their disaggregating Article 1, Section 2 from Article 6 is that's not how this court has understood it. The court has understood, okay, step 1, Article 1, Section 2 says the people can prescribe the structure of their government, and then all the rest of the constitutional amendments are that prescription. And so to say that you can use Article 1, Section 2 to circumvent the amendment power, to circumvent the co-equalness.
So to be clear, I'm not talking about circumventing anything, right? In the way I'm asking the question, right, I'm framing up a situation where the voters want to alter or reform their government, right? They use the initiative power to do that because, as I understand it, that's the only way they can, right, directly. They can do other things indirectly, but that is the only direct method they have to alter and reform their government. Do you disagree with that assertion?
I do disagree. I
Okay.
think they can directly vote up or down their legislators every 2 years.
Okay, we may just disagree on the meaning of direct, but let's go with mine for the time being.
And now there's quite a lot in beef, I would say.
No, I get it. So they want to alter, reform their government without going through the legislature. And let's say that Article 1, Section 2 provides them that right. And they find a way to do it that is constitutional, that doesn't implicate other constitutional protections. And the legislature just disagrees on a policy level and goes in and changes it, right? If we believe that the original public meaning of the initiative right was to provide the people a check on the legislature, why wouldn't we subject any sort of change to an alteration or reformation of the government to heightened scrutiny?
2 points. One is we have some of our arguments about the lack of the clause not being self-executing in the Tesla case are going to come into play.
Got those.
I'm fully I assume you disagree with me on that for purposes
Don't
of
assume anything. Don't assume anything from the questions.
For the
but-
hypothetical,
But for the
right?
hypothetical, yes.
Yeah, I get it. Get in as purest form as you can. I suppose at that point, the court could decide, they'd have to decide a few things. One, is it true that the initiative is an initiative to alter and reform the government, and that that's some kind of subset from the other 6 initiatives that have been passed? I think there's a way to describe them all as that, in the same way every law alters and reforms the government in some way. But so that would be the first question. And then the second question would be how much is too much? And you would have to square what the legislature did in Grant by giving a branch of government more power than the people did with what the legislature did here, which is by giving the Independent Redistricting Commission some authority but retaining it in the legislature. You'd have to decide in every case which of those falls on the constitutional side of the line in Article 6, which I think helps you just get back to the basic question of what's the original meaning of Article 6. To say it is to indicate that maybe when Article 6, as described by Carter, is that it's co-equal, is to say that this court doesn't need to get into that. And that we have discussed justiciability about that as a broader level, like it feels really hard to apply that kind of I know it when I see it standard. But I think the question is just answered by the text itself, which is that this ping pong or the back and forth saves the court from the constitutional decision it would have to make potentially with any subsequent initiative about whether it went too far. And that to your initial point, Article 1, Section 2 has to be read in concert. They work together, and the cases that cite Article 1, Section 2 are almost always citing them as, I don't want to call it an afterthought, but as a belt and suspenders to the case's discussions of Article 6. And the two are read in tandem, and that the people, no less than the legislature and every other branch of government, do have to work within constitutional constraints. I think our best case on that, Your Honor, is Carter plus Grant, and to say otherwise here, to not affirm the district court, will require walking back some of what the court said in those cases. More generally on the merits, both for count 5, but also counts 1 to 4, whatever the court does here has to be consistent with the Constitution. And the Constitution cannot be amended by a decree, and statutes can't be passed in conflict with the Constitution. And so in particular, at issue here is the court's power, and what Article 5 says about the court's power vis-a-vis the legislature's power. And the thrust of our brief is a little bit more modest, again, than what my friend on the other side described it as. It's that there's been the separation of powers question is, whether some of the legislature's Article 9 power has been delegated, expressly directed, or permitted to be exercised by this court. And for all the reasons we've said, we don't think it is, and that there's no constitutional provision that expressly directs or permits the court to take a second crack at the policy and political choices in the legislature's map. No different than it was beyond this court's power to tell the Ogden Transit Company in Skeen to stop at a certain part in the Ogden Valley. For all the reasons I said earlier, I don't think this is a malapportion. The claims here are not equivalent to numerical malapportionment claims. Remedying the claims here for these voters might cause harm to other voters. The best comparison of those two things is take Wisconsin, one of the first courts to recognize numerical malapportionment claims. The same court in 2021 in the Johnson decision adopted the Rucho analysis and said, we don't have the power to get into the political fray. This is also not a VRA case. And any quick look at the federal court's VRA case law will tell you that is a very difficult area to get into. It's something we've justified by this country's commitment to racial equality. And there is no way to liken the political claims here to the racial claims and VRA claims and Equal Protection Clause claims. And I do disagree about the description of the racial gerrymandering claims. So as the Chief Justice said in Rucho, racial discrimination is verboten, whether it's for good reasons or bad reasons. And what you're doing in a racial gerrymandering case, when you're looking at political data, when you're looking at traditional redistricting criteria, is trying to suss out that intent, good or bad. But was there any, did the intent to redistrict on the basis of race, did it predominate? And it would be, again, grave error to equate that sorting of voters by race, a harm addressed by the 14th and 15th Amendment in a civil war in this country, to sorting voters based on their predicted future votes. And yes, you would be an outlier state court decision. The only cases that would be similar to this one would be Pennsylvania, which very much hinges on the word equal and an equal opportunity to translate votes into seats. That text isn't at issue here, and I don't think it's fairly subsumed within free. And you would also be equating yourself with that New Mexico decision. It's unreasoned. It just says, we have a state equal protection clause and we're applying Justice Kagan's dissent. And that gets me to three very quick points with their uniform operations clause or the New Mexico approach.
I'll have to ask you to wrap it up with these two, unless there are more questions, with these 3 points.
Okay. Then I'll wrap it up just by saying I don't quite understand
you can go into those 3 points, but just quickly. Yeah. Okay.
The first is their equal protection clause test, and similarly Justice Kagan's approach, it's inconsistent with their concession that some amount of politics is appropriate. My friend said today that no amount, for purposes of testing the equal protection clause claim, it wouldn't be appropriate. And their classification doesn't make a lot of sense because one voter might vote for president as the Democratic president and the Senate Republican candidate. And last but not least, we just ask you to conclude that these claims should be dismissed for lack of jurisdiction and affirm on count 5. A remand will raise a host of issues. It will cost hundreds of thousands or perhaps more than $1 million in litigation costs, discovery for discovery's sake, because we still don't know what claim we're trying or what proof we have to bring to defend against plaintiffs' claims. And I would urge the court to take a look at Harper 3 at page 426, which tells a cautionary tale of what the remand did in that case, which is a whole lot of nothing. And that despite all the sophistication and all the computer technology, no amount of experts could give the court something to resolve as a judicial matter versus a political matter. Thank you, Your Honors.
Thank you, counsel.
Your Honors, just a few points in rebuttal. With respect to the corollary to the racial gerrymandering cases, of course, my point there was that is about whether or not that inquiry is a manageable test, not about whether or not there's different, at the outset, whether there's different levels of scrutiny for the type of issue involved. And so if the courts can suss out whether or not race was the predominant motivation behind a plan and use that standard to do that, then I don't think there's any argument to be made that the courts are incapable of applying a similar standard and reaching manageable conclusions. With respect to the absence of the word equal in the free elections clause, of course, equality is required by our Constitution in the uniform operations provision. And so those provisions work in tandem together, even if there was something meaningful to the removal of or the lack of inclusion of that in light of the historical context at the time, concluding that that was within the concept of freedom. Of course, the founders might have thought it superfluous because the Constitution separately required equality and enforceable provision. The Grant case, I think, doesn't bear any of the weight that has been given to it by the Counsel for the Legislature. Essentially what the court there concluded was a law has been passed. Does the governor have the power to veto a law that has been passed? And the court said that has that power. It has the power to call a special session. And there was really a circuitous argument from the pro se plaintiffs there to try to get to the point. They didn't raise any of the arguments that we've put forward here. Similarly, the Skeen case that was mentioned as the sort of closest thing the legislature offers to a justiciability holding of the court, the claim, as best I can tell in that case, was a claim that the common law required a train stop to be next to someone's preferred location. And all the court said was that essentially it's like dismissing it as on a 12b6 motion. There's no cause of action that's been alleged that grants one entitlement to relief. And so we have alleged causes of action here that are at the core of what the facts we've alleged show to have gone wrong and to violate those provisions. I don't think the court in Skeen ever even said it was saying that this was a non-justiciable controversy. It was just saying there isn't a cause of action. And then finally, I would say with respect to Article 1, Section 2, and this ping pong concept, that provision that all political power is inherent in the people and they have the right to alter and reform their government, this court has, in the severe power case, said that that has to be interpreted to be meaningful and can't be interpreted to be illusory. If what the legislature envisions is that the people can pass a reform effort by initiative to regulate redistricting, and the moment it passes, the legislature can repeal it. The argument today was that if they do that by 2/3 and you can't have a referendum, then I guess we're just done permanently. But even if you take them at the brief that, okay, we come back and the people gather the signatures, wait for an election year so that it can go on, an election cycle so the initiative can go on the ballot, pass it again by a majority vote, which is actually what the text of the Constitution requires, not something more than a majority vote. And then the legislature can volley that ping pong back and say, no, not enough of you voted, a majority of you voted for it, but we don't think that's enough to hold us politically accountable. If we repeal this again, we think we're still going to win because we've got the 49.7% that we've gerrymandered to equal 2/3 of the districts.
Counsel, I suppose you'd agree, and maybe it goes without saying, but the people have the right to alter or reform their government through their elected representatives, correct?
I think they can also exercise that power. I think the problem that the voters of Utah identified is that this particular alteration and reformation of the gerrymandering was not possible through that means. And so they needed to exercise their power that the court has described as superior, consistent with the text of the Constitution that places it in the people.
Yeah, and I think part of the, kind of challenging aspects of this is that under your argument, the people are effectively hamstrung from subsequently altering or reforming the government through their elected representatives.
Yes, and if the legislature is correct about this volleying aspect, Article 1, Section 2 is meaningless if the reform can never take effect. If it's repealed before you ever have the election, before you ever have the map subject to the requirements that the people have chosen to put in place. And that provision is read out of the Constitution. And that's something that this court can't let happen.
That problem has caused me to wonder about some of these other states that have specific provisions, I think mostly in their constitutions, that limit the legislature for 2 years or some period of time. maybe your argument is adequately cabined by a notion of a strict scrutiny or rational basis review, but absent that, and that's new in this argument, it does seem to be a kind of super law that not only restricts the legislature in perpetuity, but maybe even the people themselves from using the avenue of altering, amending the government through their legislature. Anyway, that's kind of what I'm struggling.
So I don't think what I think it does is it recognizes the people's inherent power within the constitutional structure that we have. And so it's not creating a super law in the sense that it's an amendment to the Constitution. The people can't, as we've recognized, the people don't have the power to initiate those amendments. So if it violates the Constitution, this court has said that that would be beyond the people's initiative power. But with respect to the historical evidence in the states that after Utah put in provisions saying, well, you can't repeal it for a number of years, but then you can, I read those to be the opposite conclusion of what the legislature does, that to the extent we look at how states looked to other states, then I think the fact that Utah took out that provision from South Dakota, and then other states passed amendments after that put that back in, or put in provisions saying, okay, there's a limitation on the repeal, but then they can do it, suggests that they were looking at Utah and saying, okay, we don't want to go quite the empowering of the people route that Utah did. We're going to specify more power to the legislature than what Utah chose to do. Thank you.
Thank you, counsel. We thank all counsel. This case has been superbly argued, both in your briefs and here today, and we're very appreciative of that. We'll take this important matter under advisement. Court is adjourned.